Okay, sir, we can begin in 5, 4, 3, 2, 1.
Good morning. I am Kenyon McDuffie, Council Member for Ward 5 and Chair of the Council's Committee on Business and Economic Development. Today's Monday, March 14th, 2022, and we are convening this public hearing virtually via Zoom. We're also live streaming on YouTube at www.kenyonmcduffie.ward5.com/live. The time is 9:04 a.m. and I'm calling to order this public hearing. Today, the committee will consider the following measures. Bill 24-441, the Credit for Reinsurance Amendment Act of 2021. Bill 24-227, the District of Columbia Financial Services Innovation and Regulatory Sandbox Creation Act of 2021. Bill 24-643, the East Capitol Gateway Eminent Domain Authority Act of 2022. Bill 24-71, the Pension Exclusion Restoration and Expansion Act of 2021. As a reminder, all public witnesses will have 3 minutes to provide oral testimony. I would ask all participants to please mute their microphones when they are not speaking. Bill 24-441, the Credit for Reinsurance Amendment Act of 2021 involves the Department of Securities, Insurance, and Banking, which is an agency that protects consumers and district residents from unfair and abusive practices, empowers district residents financially, and provides a vibrant business environment for regulated entities operating in Washington, D.C. The Credit Reinsurance Amendment Act will create a new legislative framework for ceding and assuming insurers. It will grant DISB's commissioner new powers regarding capitalization for liability assumption and discretionary rulemaking powers to implement the goals of this legislation. With that, I'm going to call for the one witness who has signed up to testify for this particular bill. And we'll see if Michael Syndrome is available. Staff, is Mr. Syndrome here this morning?
I believe he may be on the phone. I've given someone access to speak.
Okay, great. Well, can we, before we allow them, have you verified who it is who's supposed to be speaking?
Doing that now, sir.
Okay.
Morning, Mr. Attorney General. Can you hear me?
We can hear you, Mr. Syndrome. Good morning to you. It's been a little while.
Yes.
Your voice.
Once again, good morning, Mr. Attorney General. Disabled veterans served our country more than most. A good segue with this bill, the Credit Reinsurance Amendment Act of 2021, do have a question regarding it, and that is, it indicates to have provide security on page 3 of the proposed bill. Provide security in an amount equal to 100% of the assumed insurer's liability. So how is that security to be arrived? And then the Sandbox proposal, it indicates that the consumers must be residents of the district, but it doesn't prescribe a time. So in other words, to take advantage of that, if you're a carpetbagger and you just now all of a sudden appear in a district, does that make you eligible? So I think there should be a time element that's put forth in the measure. I want to extend gratitude to Mr. Molson for forwarding to me documents that I did receive. And I want to make mention of a letter that I wrote to Karima Woods back on June the 5th of 2020. You heard me right. Today is March the 14th of 2022. 2 years passed, and I have yet to get a written response. And it's regarding DISB versus Antonio Almanero in number SB NI 0813. The good commissioner entered a final order, which is nonsensical. I'm facing foreclosure, and I implore you and the council to extend the foreclosure eviction moratorium, which is due to expire, I believe, in June. Most of us are still struggling due to COVID, unemployed. We don't have excess funds to keep our home. And being homeless ain't no joke. Cold outside, being homeless ain't no joke. So this has been ongoing for a number of years. And Antonio Almanero was cited by Maryland. In fact, there was an article written, Baltimore company issued cease and desist over unregistered securities. And the article appeared on February 1st of 2010 in the Nick Reeves, I'm trying to see here, the article caption, and in the body indicates that Patuxent Management LLC, Patuxent Development Inc., and Antonio Almanero are also not registered with division as broker-dealers, securities agents, investment advisors, or investment advisor representatives. The lure of a secured rate and the appeal to a pension or IRA funds are clearly aimed at persons with concerns over retirement funding, Ganster said. This was the Attorney General at the time. The absence of any filings with my office indicates the promoters are not adhering to state law and may not even be identifiable should the investment go bad, which raises flags too with what we got on tap here. It's important that enforcement be used, and it hasn't in my instance. Again, there is a worthless final order with restitution of a defunct shell company of Almanero to the tune of $200,000, which would save my home. But because it's defunct, it doesn't exist. It's been non-existent for years. It's worthless. As I pointed out in my letter, and I forwarded that to Mr. Molson, and I'd like for him to get you a copy of it so you can intelligently respond and take appropriate action with the good commissioner against Almanero to save my home. Plain and simple, Almanero indulged in securities fraud. They went to the Office of Administrative Hearings. They were shot down because it was only indicated there's one victim. Well, there's been multiple victims. And the difficulty, too, is with DISB, they only have one financial fraud investigator, Robert Laprota, who is excellent. And he has no vehicle. And then there is his boss, but with
Mr.
only
Syndrome, I'm not sure, you're on the phone, so you might not be able to see the clock that we have present, but I'll let you run more than a minute over your time so you can get what you wanted to testify to on the record. If there's anything else you'd like to provide us that you haven't already about this matter, then please feel free to do so and we'll incorporate it into the record.
Yeah, I'd like for you, Mr. Attorney General.
Thank you for your testimony, Mr. Syndrome. We're going to turn next to Associate Commissioner Philip Barlow, who represents DISB. And Associate Commissioner Barlow, you can begin your testimony.
Thank you. Good morning, Chairperson McDuffie and members of the Committee on Business and Economic Development. My name is Philip Barlow, and I am the Associate Commissioner for Insurance at the Department of Insurance, Securities, and Banking, or DISB. DISB regulates insurance, securities, banking, and other financial services in the District of Columbia. Our mission is threefold. First, cultivate a regulatory environment that protects consumers and attracts and retains financial service firms to the district. Second, empower and educate residents on financial matters. And third, provide financing to district small businesses. Thank you for the opportunity to testify today on Bill 24-441, the Credit for Reinsurance Amendment Act of 2021. The bill would incorporate the most recent National Association of Insurance Commissioners accreditation requirements that allows insurers to receive credit when reinsurance is ceded to an assuming insurer under certain conditions, and grant the commissioner additional rulemaking authority to implement these new requirements. The amendment is intended to incorporate the relevant provisions of the bilateral agreement between the United States of America and the European Union on prudential measures regarding insurance and reinsurance, commonly referred to as the Covered Agreement, which was signed on September 22nd, 2017. The covered agreement would eliminate reinsurance collateral and local presence requirements for European Union reinsurers that maintain a minimum amount of funds equivalent to $250 million and a solvency capital of 100% of the covered agreement requirement. Conversely, U.S. reinsurers that maintain capital and surplus equivalent to 226 million euros with a risk-based capital of 300% would not be required to maintain a local presence in order to do business in the EU or post collateral in any EU jurisdiction. On December 18th, 2018, a similar covered agreement was signed with the United Kingdom. In addition, these revisions to the law extend similar treatment to qualified jurisdictions and accredited NAIC jurisdictions. The covered agreement and the Dodd-Frank Wall Street Reform and Consumer Protection Act prohibit the U.S. from imposing reinsurance collateral or local presence requirements that result in less favorable treatment for EU or UK reinsurers. And state insurance measures cannot be inconsistent with the covered agreements. The Dodd-Frank Act states that the director of the Federal Insurance Office shall preempt any jurisdiction's laws to the extent their laws are inconsistent with the covered agreement and result in less favorable treatment of EU or UK reinsurers. The NAIC recommends that states and jurisdictions such as the district adopt the revisions substantially similar to the model to best avoid the possibility of federal preemption. Likewise, the current NAIC accreditation standards require the district to adopt the legislation and regulations that are substantially similar to the NAIC model. Accordingly, the proposed bill meets the NAIC's substantially similar requirement, making no revisions to the model. Finally, the covered agreement requires states to adopt revisions to the model prior to September 1st, 2022, which is the date by which the FIO must complete its federal preemption reviews. The NAIC recommends that all states and jurisdictions adopt the revisions to the law and regulation no later than July 1st, 2022, to give the FIO time for its federal preemption analysis. The insurance marketplace depends upon the availability and affordability of adequate reinsurance. The proposed changes to the law help regulators distinguish financially strong reinsurers from weak reinsurers, irrespective of their country of domicile, which in turn will provide greater assurance that companies will be able to meet its obligations to policyholders. Thank you for the opportunity to testify on this bill, and I'm happy to answer any questions that you have.
And thank you for your testimony, Associate Commissioner Barlow. I do have a few questions for you that I'd like to ask right now and may have some follow-up after the hearing. One of the questions I want to start with is sort of a baseline and some feedback. I'm going to ask you if you don't mind. I don't know if while I'm asking the questions and you can unmute, that'd be great. Thanks. That helps with the feedback or prevent the feedback. Is reinsurance or assumption of obligations a widespread or common practice in the industry?
Yes, there are various reasons why insurance companies would use reinsurance, but mainly it's to help minimize the risk on the companies writing insurance so that they don't wind up with too much risk, the potential for too big a loss from one claim. But there are various other reasons that reinsurance is used in the insurance industry, but yes, it is widely used.
And the Credit for Reinsurance Amendment Act allows assuming insurers from reciprocal jurisdictions to assume ceding insurer liabilities. These reciprocal jurisdictions include insurance companies headquartered or domiciled in non-U.S. jurisdictions. Do you anticipate passing regulations to provide additional oversight or compliance requirements for companies based in non-US jurisdictions?
We do anticipate there are rulemakings that implement the requirements of the legislation that have been developed through the NAIC that are in compliance with the covered agreements, and as soon as the legislation is adopted, we will also move to adopt the rulemakings.
And the act states that the commissioner will establish by regulation a methodology to calculate the capital and surplus requirements that assuming insurers must maintain to assume ceding insurer responsibilities. Acknowledging that the rulemaking has not occurred, can you provide the committee some insight into what you believe the methodology will include? Is this also included in the NAIC regulation you plan to adopt, and how often do you plan to reevaluate and update the methodology?
Yes. So the department would simply adopt the standards that are developed through the NAIC. I don't know at this point how often the NAIC plans to reevaluate the standards, but I think they will look at both the experience of the insurers providing the reinsurance and market conditions to determine when a reevaluation is appropriate.
Okay, and this measure also, Commissioner Barlow, requires assuming insurers to pay all final judgments wherever enforcement is sought. So how do you all anticipate that the department coordinating or working with OAG, the Office of the Attorney General, or some other entity to enforce any judgment?
So again, this mostly impacts reinsurers that are domiciled outside of the United States. So I would imagine, I will say I'm not a lawyer, so but I can get a more specific answer from our legal staff if you'd like. But I imagine that these things are addressed. The settlement of these things is addressed through the covered agreement, and so given that these are international reinsurers, it might involve bringing in the federal government. But typically, the reinsurance arrangements cover more than one jurisdiction. So it's not like it's likely to be just the district trying to enforce a provision. It's likely to be through the NAIC that the United States is trying to enforce a provision. So I imagine that we would work with both our Attorney General and with the federal judicial system to ensure that the claims are paid.
And in terms of the department's capacity and staff with respect to what's being proposed in this measure, do you all anticipate needing to hire any additional staff, FTEs, if this measure is enacted?
We do not. We believe that we have sufficient staff to implement this with the current resources that we have.
Okay, and then the measure also allows the commissioner to add an assuming insurer to a list of assuming insured that may operate in the district if the assuming insurer operates in a jurisdiction that is accredited by the National Association of Insurance Commissioners and has been added to the list of improved assuming insurers in that jurisdiction. Will the commissioner perform additional due diligence to confirm that assuming insurers should operate within the district, or is it just once it's added to another list, then it's some sort of automatic process?
The reinsurers have to submit an application to us, pay a fee to us. So we will get that. application and review it and make sure that they meet all the requirements, and then we will publish their names on the list as appropriate to the district. I don't think that we would, assuming they meet all the requirements, I don't believe that we would have any authority to deny an applicant, but we will. But we have developed a process to, we have developed an application and a process to review the companies and to make sure they meet all the requirements before we authorize them in the district. I think you're on mute, Councilmember.
Thank you for that. If they've been added to a list of approved assuming insurers by the NAIC, and you all discover something in your application process, what course would you take to identify, or at least to provide that information to the NAIC? Like what authority does the district have to not approve somebody who's already been added to the other list by the NAIC?
So, so each reinsurer, even though these are international reinsurers, has a local jurisdiction in which they are is sort of their primary regulator. So if we found any issues with the application as we were reviewing it for approval in the district, we would bring it back to the attention of the state in which they were originally granted authority in the U.S.
Okay, but so the way it reads, the measure before us today grants the commissioner significant rulemaking authority, and you mentioned what would be provided by the NAIC, and essentially sounds like adopted by the district. But the measure before us also grants you discretionary powers regarding the imposition of certain additional requirements on individual insurers and the ability to revoke or suspend eligibility for an insurer. The Act does not specify what the standard of review when reviewing these actions. And so should we be assuming an arbitrary, capricious standard? What are we looking at when it comes to this process for you all in terms of these discretionary powers that are outlined in this proposed measure?
Again, I don't really anticipate that the district exercising these kind of powers on our own. This would likely be done in concert with the other states in which the reinsurer was doing business. But in order to, you know, we have a state-based system of regulation of insurance, and so we would have to, in order to take action for the District of Columbia, the commissioner would be the party who would have to take action to affect the coverages in the district.
Okay. All right. I don't have any additional questions at the moment, Commissioner Barlow. Is there anything else you'd like to add to the record before we turn to the next measure on the agenda?
No. Thank you.
Testimony. I appreciate it. And thank you, Mr. Syndrome, earlier for your testimony on this measure. I'm going to turn next to the second measure before the committee. This measure is Bill 24-227, the District of Columbia Financial Services Innovation and Regulatory Sandbox Creation Act of 2021. This measure seeks to create a regulatory framework within the District Department of Insurance, Securities, and Banking to assist innovation within the financial products and services sector. This program would remove certain regulatory burdens for innovative financial companies operating within the district for a 2-year period. If passed, the legislation would also grant the DISB commissioner new powers to efficiently operate the program both for participants and residents alike. And so I'm going to turn to our public witnesses now. And again, remind participants who are about to testify to please mute their microphones when they are not speaking. Let's see. We have a couple people who signed up to testify, Marquis Allen and Drew Maloney. I see both are present, so I'm going to turn to Marquis Allen first. Good morning to you. Thank you for joining us. You begin your testimony.
Morning, sir. Chairperson McDuffie, committee members and staff. My name is Marquis Allen. I'm Chief Executive Officer of Clinical Squared, Inc., operating from Ward 5 here in the district. Thanks for allowing me to testify in support of Bill 24-227. I'll take a moment to share my background with you and the members of the committee. I'm a resident and native Washingtonian. I've worked in the technology industry for over 25 years in the financial, nonprofit, and healthcare sectors. My company, Clinical Squared, was founded in 2019 and provides consulting and tech education services, data migration and visualization tools, and builds full stack software solutions using innovative technologies like blockchain. I'm also a member, contributor, and collaborator in several organizations dealing with innovation technologies, including the Blockchain Task Force for HIMSS, the Blockchain Task Force for IAC, and the Government Blockchain Association, for which I am the chairman of the Healthcare Working Group. In November of 2019, Mayor Bowser appointed me to serve on the district's Financial Services Regulatory Sandbox and Innovation Council. I've been very excited for the opportunity to help with this. As a member of the district's FSR-SIC, we researched the feasibility of creating a regulatory sandbox in the district. And after careful consideration, the Sandbox Council unanimously agreed that the District of Columbia would benefit from the creation of a regulatory sandbox. Many of my colleagues and associates in the technology and innovation sectors heartily support the district's efforts to create a welcoming environment for novel technology solutions to be created, researched, and refined, and several have verbally committed to assisting in whatever way they can. My fellow council members and I reviewed demos of technology platforms and have fielded verbal commitments from solution developers like Block Apps in New York City and Burst IQ in Colorado, both blockchain as a service providers who could assist with the technical construct required for the safe operation of the solution builds. I've personally spoken to business leaders, technologists, and use case developers from our city who see the regulatory sandbox as an opportunity for them to demonstrate their technological approaches to delivery of financial instruments. One example that comes to mind is the Breadcoin project, which passes out minted coins to food insecure and homeless populations right now in wards 4, 5, 7, and 8 primarily. They receive about $250,000 in charitable donations per year. The Breadcoin innovation team is interested in participating in this regulatory sandbox to explore using blockchain technology to track donations from donors in a transparent way and possibly turn their physical coin into a digital currency. In the months leading up to the district council's review of this legislation, I've also been approached by innovators and legislators from other states and have been made aware of the regulatory sandbox initiatives they are undertaking locally to not only create an environment for research and refinement of fintech mechanisms using innovation, but also to create a competitive advantage by incentivizing thought leaders in these new technologies to come create solutions, bring jobs, and do business in their state.
Marquis Allen.
Yes, sir.
I'm not sure if you can see the clock, but your time has expired. If you want to just quickly wrap up so we can turn to our next witness.
Absolutely. Yeah, I think the timeliness of this legislative review is perfect. The White House and President Biden has just signed an executive order instructing the federal government to explore possible uses of and regulations for digital assets like cryptocurrencies and requiring responsible development of these assets. Instantiating this sandbox positions DC to support that development and refinement in our city. And in closing, I'm confident that the establishment of this regulatory sandbox will spur innovation in the district. It will enhance the district's reputation as a leading city for entrepreneurs and businesses in this innovation space.
I'm going to have to cut you off a bit because I wanted to get you to summarize it, but we do, I believe, have your written testimony.
Thank you, sir.
And we'll make sure we incorporate that into the record. I'm going to turn next to Drew Maloney, and you'll have 3 minutes to provide the testimony. Thank you for being here with us this morning.
Thank you, Chairperson McDuffie, committee members, and staff. I am Drew Maloney, President and CEO of the American Investment Council. I was born in Washington, D.C. and spent the last 25 years in this city working and raising our family, so the city's future is important to me. Thank you for allowing me to testify in support of Bill 24-0227, the District of Columbia's Financial Services Innovation and Regulatory Sandbox Creation Act of 2021. The American Investment Council is the leading advocacy and research organization for private equity and credit based in the District of Columbia. We focus on promoting private equity and growth capital investment industry to lawmakers and the public at large. Last year, private equity invested more than $1 trillion into the economy, with almost 75% of the investments going to small businesses. In DC alone, more than $3 billion was invested here in 2021. We are investing across the DC community. In fact, more than 1/3 of the businesses operating in Union Station have received private equity funding. I previously served as the Assistant Secretary of Treasury. Prior to that, I was a corporate officer at Hess Corporation and CEO of Ogilvy Government Affairs. In addition, I served on the staff of several members in the House of Representatives. I have more than 25 years of experience in both public and private sectors. In November of 2019, Mayor Bowser appointed me to serve on the district's Financial Services Regulatory Sandbox and Innovation Council. As a member of the District Sandbox Council, we researched sandboxes in other jurisdictions, carefully and considered the benefits of enacting regulatory sandbox legislation here in the district. We concluded that creating a regulatory sandbox would support the Bowser administration's effort to attract technology companies and entrepreneurs to the district. I believe a sandbox will thrive here in DC, and that is currently home to many technology companies and entrepreneurs. The district sandbox will also benefit from its proximity to the highly ranked universities, many of which have strong technology, math, and science programs. Other jurisdictions have used their sandboxes to attract a variety of financial services businesses that protect consumers and consumer loans, innovative investment advisory, novel money transmission businesses, and I am confident the district will attract similar businesses when its sandbox is set up and running. In closing, I am confident the Department of Insurance, Securities, and Banking will be able to successfully implement the regulatory sandbox while ensuring adequate consumer protections. I strongly encourage the council to enact Bill 24-0227 at the earliest possible date. Thank you for allowing me to share my testimony with the committee today, and I am happy to answer any questions that you may have. Thank you.
And thank you for your testimony. I want to thank you both for your testimony this morning. Marquis Allen, I know I cut you a bit short, but as I mentioned, we'll make sure that your written testimony, both of your written testimonies are incorporated into the record. You both participated in the council that the mayor established, and you both support the measure before us today, Bill 24-227. Do you all have any concerns with the way that the measure is drafted, or do you fully support every aspect and provision of the proposed legislation?
Drew, I can go first. I don't think overtly we have any concerns per se. However, we broke down into different service committees, and we have a sandbox structure committee that is concerned with who is a participant in the sandbox, the rules by which they're governed, the reporting that the district is going to require. And so after the instantiation of this legislation, we plan on kind of dotting all those I's and crossing all those T's to make the rules of engagement very clear so that they benefit the district. They provide the kind of innovation research that we're looking for, and also offer entrepreneurs the opportunity to enter the space in financial services using innovation.
Yes, Mr. Chairman, I mean, my only concern is the longer we wait, the more we're losing out to other states. Arizona, North Carolina, Hawaii, Nevada, Utah, West Virginia have all done these regulatory sandboxes. And, you know, DC is such a wonderful area to establish one that you know, I think the quicker we can do it, the better we're going to be.
Okay, I thought you were finishing up. I don't know if you finished your statement, but I do want to ask you. You mentioned other jurisdictions, Ms. Maloney, and so I want to ask you about some of those other jurisdictions that you're familiar with Have you seen where they've done things differently than what's being proposed in this bill that have in some way benefit or detract from what we're trying to accomplish in Bill 24-227? Are there things that we should have considered that we haven't here?
Well, Mr. Chairman, I'm not an expert on every jurisdictions, and it looks like there's probably been about 10 or 12 others. It's a relatively new concept. The first sandbox was created in 2018 in Arizona, and is having, great success in Arizona and attracting new companies. I would say the one state I did notice that had the biggest difference from the other regulatory sandboxes, I believe, is Utah, which doesn't limit the sandbox just to fintech and financial services. It's a broader sandbox that tries to encourage a lot of different technologies to come in. So, I guess in some respects, it could be widened, but I think for the focus of where we are right now, I think keeping it focused on the fintech and financial services and at least starting there and expanding it later would be a wise choice.
So I don't know how long you all have to stick around, but if you don't get a chance to hear the Office of the Attorney General's testimony, I would encourage you to check the record because they in that testimony that I assume will be read by Mr. Weissman this morning, they raised some really serious concerns about the bill before us, particularly as it relates to consumer protection. And they'll testify that it really gives broad powers to the commissioner without real checks. I asked my staff to provide me with a list of the members of the Sandbox Council that you all were a part of, because I'd be interested to see whether the Office of the Attorney General was a member of that council or any other agencies that participated in the process. And so they talk about the broad powers of the commissioner. They talk about concerns about the definition of innovation in the bill. They talk about the monetary limits that are in this proposed bill relative to what they've seen in other jurisdictions around the country. Those are some of the things that they have mentioned in their testimony. And I don't want to get out ahead of the OAG, but I wanted to see if you all had any immediate response to some of the things I just mentioned.
I haven't read through the Attorney General's testimony, but there are always going to be those folks that can read through any piece of legislation and identify things that they would like to see done differently. I think from our perspective, the broader it was, the better. We did have various folks from the consumer protection side on our council, and we were very aware of that. But in these sandboxes, one of the things you have to do is you have to trust that the regulators will be able to monitor that. And sometimes you got to take a little bit of risk. And that's how you attract entrepreneurs. If you just want to protect the incumbents, then you can find all kinds of reasons why things can't get established. But this is to really incubate new technologies here in Washington. And I think sometimes you got to take that type of risk.
I appreciate the comment about taking risks. It may give consumers and others a little bit more comfort if perhaps there was a role for the Office of the Attorney General or some other agency rather than simply have it all come through DISB and the commissioner with the broad authority that rests with the commissioner as this bill is currently drafted. So if you hear the testimony today, I'll get a chance to read it later and you hear the comments, and please feel free to follow up with the committee and provide your additional testimony in writing. But we do appreciate your testimony this morning. Anything else before we move to the government witnesses, either of you?
Thank you.
Thank you.
Thanks again for your testimony and your participation in the council.
Thank you, Chair.
Okay, we're going to turn next to our two government witnesses. We have Kramer Woods, who's the Commissioner of the Department of Insurance, Securities and Banking, as well as Benjamin Weissman, Director of the Office of Consumer Protection within the Office of the Attorney General. Thank you both for being here this morning. We're going to turn first to Commissioner Woods. Good morning.
Great. Good morning, Chairperson McDuffie. I just want to bring to your attention, I see in the chat that there's question about, I guess, 2 additional witnesses that are signed up to testify. So just want to bring that to your attention. But happy to proceed.
Give me a moment. I don't think they signed up prior to today, or at least the notice of the agenda being circulated. So I'm not sure they're going to get the opportunity to testify this morning. They can always provide their testimony in writing. Give me one moment.
Okay.
It's my understanding from committee staff, commissioners, you mentioned there are a couple more witnesses, and we do want to give them the opportunity to testify here this morning. We appreciate them both reaching out to the committee to sign up to testify. We're going to turn first to Rory Murray, followed by John Bratsakis.
Hi, Chairman. I actually work for John. Can he go first? And I'll just do a quick follow up to his.
Well, I'm going to give you both 3 minutes to testify. You can go in whichever order you want.
Thank you. All right, John will go first. Appreciate it.
Mr. Chairman, thank you very much for the opportunity. My name is John Bratsakis, and I represent the Maryland DC Credit Union Association and our 30 credit unions in the district that represent 300,000 district residents. As a quick background, I spent 25 years of my career as CEO of a credit union and also senior executive at large credit unions before coming here. And I won't reiterate our full testimony that's already been submitted, but I do want to just bring a couple of reasons as to why we respectfully oppose the legislation as it's submitted. Allowing financial institutions or fintechs to operate without proper licensing and supervision goes against safety and soundness practices upon which the financial services industry is built upon and which the district has worked diligently to uphold. I think one of the things that we've seen over the last 15 years is that unregulated or lightly regulated companies that work within the financial institution area can be dangerous. Credit unions, it was talked about incubating. Credit unions have incubated and are investing in a variety of fintechs, especially when it comes to blockchain, cryptocurrency, digital banking, artificial intelligence, data analytics, and also when we look at machine learning and how we can take that and better serve the constituents of the district and also credit union members throughout the country. We'd appreciate the ability to take a more active role in developing these technologies and leveraging what credit unions are already doing within the regulatory environment that they operate, and how they can bring those technologies in an orderly fashion to the marketplace. There are hundreds of fintech companies that are working with credit unions that are innovative, but are also doing it under the umbrella of the regulatory structure to ensure safety and soundness of the institution, but also protections for consumers. With that, I'll turn my time over to Rory to fill in any blanks from a technical standpoint and then answer any questions you might have.
Sure. Thank you for your testimony. Roy Murray, you'll have 3 minutes to provide testimony if you need that much time. You can begin your testimony now.
I won't, Chairman. I'll just direct you to page 3, lines 62 through 68 of the bill. That's where the crux of our issue is. It's probably also where the crux of the Attorney General's issues are, if it's consumer protection related. First, under Section A, it says that these are used to test innovative financial products and services without meeting the regulatory requirements. Financial services are way too important to be using people as test subjects. Regulatory requirements are there for a reason. And then if you look under B, it says the commissioner shall consider the need to ensure consumer protection. That is just setting up a very arbitrary rulemaking process. I've sat in front of you and your committee and the committee of the whole dozens of times over the years for consumer protection related bills. And to put something through that doesn't put consumer protection at the forefront, no matter what it is, it's just not good for the people. It's not good for the companies. It's creating an environment that is bound to put somebody in a bad place. So we are 100% in support of innovation. Happy to work with the district in any way to push that forward. But the bill as drafted does not create anywhere near enough the safety and soundness and consumer protection measures that we feel is appropriate. Thank you.
And thank you both for your testimony this morning. We appreciate you providing it. I don't know if I have any additional questions. I appreciate the points you all raised, and I take it I'll have some additional concerns raised by the OAG based on the written testimony that provided to the committee in advance of today's hearing. Do you know, though, if either of you, whether anyone in sort of your industry, within the credit union industry, were represented as a member of the council that was established?
Well, we had one, I don't know, her name is Elizabeth Argudian, and she was the Director of Advocacy for Credit Union National Association. She recently went to an in-house position with the NCUA. So I don't know if she's still on that commission or not, but I'll be happy to follow up.
The NCUA is?
It's the National Credit Union Administration. It's the regulator for federally insured credit unions.
Okay, and I don't know if you all interacted with her at all, or got a point of view shared with you by her in terms of her experience on the council, or maybe some of the concerns that you all raised this morning?
Not on this particularly, but be happy to follow up with her.
All right, well, no, I appreciate your testimony here this morning. Thank you for providing it. I'm glad we're able to capture that as part of the record.
Thank you very much, Chairman.
Now we're going to turn to Commissioner Karima Woods. Good morning to you again. You can begin your testimony whenever you're ready.
Thank you, and good morning to you again, Chairperson McDuffie, committee members, and staff. I am Karima Woods, Commissioner of the Department of Insurance, Securities, and Banking, also known as DISB. And on behalf of Mayor Muriel Bowser, I appreciate the opportunity to testify today on Bill 24-0227, the District of Columbia Financial Services Innovation and Regulatory Sandbox Creation Act of 2021. DISB's mission is threefold. First, to cultivate a regulatory environment that protects consumers and attracts and retains financial services firms to the district. Second, to empower and educate residents. And third, to provide financing for small businesses. We accomplish this by effectively regulating the district's financial services industry to ensure district residents have access to a wide array of financial services and service providers. DISB also promotes a positive business climate that encourages fair and open competition, supports economic development, and fosters business growth in the district. I am pleased to testify today on this bill, as the implementation of a regulatory sandbox is one of DISB's key objectives as we review existing barriers businesses face while operating in the financial technology, fintech, insurance technology, insurtech, and regulatory technology, regtech categories, and seek to encourage innovation without jeopardizing consumer protection. The creation of a regulatory sandbox is a critical tool to spur innovation in the district's financial industries and provide new financial services and products to district residents. A regulatory sandbox is a framework set up by a regulator that allows innovators to conduct live experiments in a controlled environment under a regulator's close supervision. The district is uniquely positioned to benefit from the establishment of a sandbox, as it is home to a vibrant technology sector, several highly ranked universities, a diverse population, communities with a higher than average educational attainment and household income, and a significant number of unbanked and underbanked residents. The passage of this bill will enable controlled testing of new innovations within the district, potentially resulting in more targeted programs and innovations, providing better financial products and services to district residents, and inclusion of those residents who may be underserved in the current financial marketplace. A sandbox will also allow DISB to collect data on the effectiveness of certain changes and innovations, including greater data on where reforms are needed to accelerate equity in the financial markets. B24-0227 would establish a regulatory scheme that would allow a person or firm temporary access to the district market so that it may test a new innovative financial product or service without necessarily having to comply with all existing regulatory requirements while operating within the sandbox. Interested persons or firms would be required to submit an application that includes detailed information about the proposed product or service, their capacity to administer and analyze the effectiveness of the proposed product or service, and their ability to ensure district consumers are adequately protected during the test period. The department would then carefully review this information and conduct an in-depth background investigation to determine if the applicant should be granted a license and allowed access to the district's market. Approved applicants will be allowed to operate for 24 months with a pool of no more than 25,000 district residents. The legislation grants the commissioner authority to examine the activities of a sandbox participant and to access the company's records, documents, and data. Additionally, the commissioner would be required to investigate consumer complaints arising under sandbox activity and take enforcement action against those individuals or companies who violate the law. Companies that are approved to operate within the sandbox may, if warranted, receive a waiver from certain district laws and regulations that generally govern operations in the financial services industry. Waivers are an important aspect of a regulatory sandbox because without the ability to innovate beyond the strict boundaries of the current regulatory environment, the sandbox itself would be moot. However, a waiver from certain district laws or regulations does not provide an applicant with the freedom to operate with impunity or avoid the district's robust consumer protection requirements. In fact, the bill explicitly requires sandbox participants to comply with all consumer protection laws as part of their proposal. DISB's robust oversight of sandbox participants will ensure the participants do not engage in activities that harm district consumers. Participants found to be in violation of district consumer protection laws may be subject to referral to the Office of the Attorney General for civil or criminal action. We recognize that there may be concerns about competitive balance in the marketplace for companies that receive waivers as part of their participation in the sandbox. However, a regulatory waiver granted by the commissioner would not extend outside of the product or service being tested in the sandbox. Any waiver request will be thoroughly reviewed by the department to ensure that they are necessary to allow the innovation to be properly tested and that such a waiver will not harm district residents. In closing, I would like to thank you, Chairperson McDuffie, for your leadership and support The creation of a regulatory sandbox will help to spur innovation in the district's financial industries and provide new financial services and products to district residents without compromising existing consumer protections. I encourage the council to enact Bill 24-0227. I look forward to working with the committee, and I'm joined here today by my colleague Dana Shepherd, and we are both happy to answer any questions that you may have at this time. Thank you.
Thank you, Commissioner Woods, for your testimony. I'm going to turn next to Benjamin Weisman. And good morning to you.
Good morning, Chairman McDuffie, council members, staff, and residents of the district. My name is Ben Wiseman. I'm the director of the Office of Consumer Protection and the Office of the Attorney General. I'm pleased to provide comment on behalf of Attorney General Carl Racine and express OAG's reservations concerning Bill 24-0227, the Sandbox Bill. The Office of the Attorney General supports the laudable goal of encouraging new and innovative businesses in the District of Columbia. Responsible innovation in the consumer financial marketplace has the potential to provide consumers with expanded choices, lower prices, and greater access to credit, especially for district residents who have been left behind by traditional lending and other financial models. We're concerned, however, that the Sandbox Bill does not adequately protect district residents. Regulatory sandboxes purport to foster experimentation and innovation by providing companies with broad immunity from rules and laws that would otherwise apply. Indeed, the regulatory sandbox proposed in this bill would provide broad legal immunity to fintech companies to purportedly foster experimentation and innovation. Fintech, shorthand for financial technology, is a phrase often used to capture a wide range of financial products and services that rely on new technologies and the internet. It includes online lending products, digital investment products, online payment systems, and even cryptocurrency. For example, Venmo and Cash App are fintech companies that offer peer-to-peer payment services. Promoting innovation, however, should not come at the expense of district consumers. And OAG has seen firsthand the risk posed by many new fintech products. Regulatory sandboxes are inherently dangerous because they allow new, untested financial products and services to be tested on consumers without normal legal protections in place. And as I'll explain a little bit later, OAG has seen how risky fintech products can harm district residents. OAG has taken action against online fintech lenders that purport to offer easy access to small dollar loans, when in fact, the loans they provided were predatory products that had illegal interest rates that trap consumers in cycles of debt. A regulatory sandbox might be used to provide cover for such risky and harmful products. Because of the dangers inherent in regulatory sandboxes, very few jurisdictions have enacted laws enabling them. Most states, including those that share the district's values of strong protections for vulnerable and low-income residents, have rejected sandboxes in favor of a more cautious and consumer-oriented approach to fintech companies. Indeed, when the Consumer Financial Protection Bureau under the Trump administration proposed a regulatory sandbox, General Racine joined 22 attorneys general to oppose the proposal. And a coalition of 50 public interest groups, including the National Consumer Law Center, also wrote a letter opposing the program, noting it could put consumers at risk. OAG urges extreme caution in enabling these types of loopholes for fintech companies. And rather than providing companies with broad immunity in the form of a sandbox to test products on vulnerable or low-income residents, we should be strengthening our consumer protection laws and updating them as appropriate to meet the needs of innovative tech. Innovation must occur within a framework that maintains strong protection for consumers and does not unfairly advantages businesses that follow the district's laws. OAG is actively engaged in ensuring fintech companies comply with district law. In fact, our office is one of the leaders in this space across the country. We have several ongoing investigations of fintech companies that interact with district residents. These investigations are focused on a myriad of issues, including whether these companies are misleading district consumers. In addition, in 2020 and 2021, OAG brought lawsuits against two fintech lenders, OppFi and Elevate Credit, that provided thousands of loans to district residents with interest rates as high as 250%. The district's rate cap is 24%. These fintech lenders claim that they were only loan servicers, not lenders, providing innovative algorithms and platforms to facilitate lending by state charter banks. Our investigation showed, however, that the companies were in fact the true lenders behind the loans and thus liable under the district's consumer protection and usury laws. We recently reached settlements with OppFi and Elevate Credit which will return at least 4.8 million in restitution to district residents for amounts they paid that they shouldn't have above the interest rate cap, and result in over $1 million in additional debt relief to district consumers. OAG has also been active on the legislative front. In 2021, we introduced legislation that would ban companies from using algorithms that discriminate against people who apply for a job, seek a place to live, or try to get a loan. Automated decision-making algorithms are often employed by fintech companies as innovative tools, but they can reflect and replicate historical bias and exacerbate inequalities in marginalized communities. It's abundantly clear to our office that the fintech area, though full of promise for helpful innovation, also requires vigilant oversight and enforcement to prevent abuses. Now, in addition to our concerns with sandboxes generally, we have serious concerns with the sandbox that would be created by this bill, and I will touch on a few of them. First, given OAG's vast experience with fintech companies and consumer protection enforcement, we're concerned that the proposed legislation does not include any involvement of the Office of the Attorney General. Rather, the authority to provide broad immunity from liability rests solely with one person at one district agency. This framework is problematic because it could undermine OAG's critical consumer protection enforcement activities, including the enforcement activities just discussed. For example, a target of an OAG enforcement action may try to seek shelter through the sandbox waiver. A more appropriate and consumer-oriented framework would require OAG and potentially other district agencies to review and approve any waiver. For example, in North Carolina, their sandbox bill has an 11-person innovation council that includes members of the public as well as the Attorney General that are required to approve sandbox applications. Second, we're concerned with the broad powers granted to the commissioner. The bill would allow the commissioner to waive important consumer protections for any reason in the sole discretion of the commissioner. The bill does not include any approval criteria or factors that the commissioner must consider before granting a waiver, and there's no requirement that the commissioner provide a reason or that the justification for granting a waiver is made public so that district residents can provide input. OAG does not support providing such broad safe harbors to companies without meaningful transparency. Third, the proposed monetary limits are too high. Lenders can offer loans in amounts of up to $15,000 with aggregate loans of $50,000. This is far greater than limits in other jurisdictions, and for many district residents, such losses would be catastrophic. Fourth, the proposal allows companies to experiment on up to 25,000 district consumers. Arizona, for example, only allows up to 10,000 consumers. Arizona has a population of 10 times the districts. Simply put, this puts too many district residents at risk. OAG believes in supporting responsible innovation, but fostering innovation should not include providing broad grants of immunity to companies that put our consumers at risk. Bill 24-0227 would do exactly that, allowing companies to offer risky products to tens of thousands of district residents without strong consumer protections or meaningful transparency. We urge the council not to enact a regulatory sandbox. If it is to do so, we strongly suggest that this bill be modified to better protect district residents. We'd be happy to work with you, Chairman McDuffie, the council, the commissioner, and DISB to suggest modifications to this bill. Thank you.
And thank you both for your testimony this morning. I do have some questions for you. I think I'm going to start off my questions with Commissioner Woods. In terms of cost, what are the anticipated costs of establishing this sandbox, Commissioner?
We don't have any anticipated immediate cost other than the hiring of additional FTEs to support the sandbox.
And is it your position that the agency would be able to absorb those costs, or is there likely going to be an increase in the agency's budget as a result of this, if it were to pass?
I would say in its initial phase, yes, we will absorb that cost. We are proposing additional FTEs in FY23 to accommodate the expansion of this program.
Okay. And in terms of I've heard you articulate this in your testimony in terms of eliminating burdens on innovation for certain financial products. We heard earlier from some of the public witnesses about creating an environment that would be attractive for innovation in financial services and fintech. Are there certain things you can highlight in terms of the regulatory burdens that would be eliminated? Why is this so important for the District of Columbia to move forward with?
Well, I would say that there are a couple of kind of high-level reasons. One, we want to be able to enable businesses to test the overall feasibility of providing new and innovative financial products and services that are beneficial to consumers. Some of those benefits could include reducing transaction costs, opportunities to expand financial services and products to unserved and underserved communities, and also greater convenience and efficiency. It also would enable the department to collect data from the participants and consumers that could be used to support some of the other reforms that I noted in my testimony that will enhance equity, eliminate biases, and also proxy discrimination in certain products and services. Overall, it's important that I think that we focus on the role that innovation would play in the regulatory sandbox and how it can further aid and support some of the district's other activities around attracting financial technology companies to the district. I know the Deputy Mayor's Office is focused on that, particularly as they're working on the creation of an innovation district. And so it's important that we have these different vehicles in place to effectively attract the fintech companies to the district in a controlled testing environment.
In terms of the process that companies would have to undergo to be approved, you anticipate there's going to be an application process. Are there going to be specific guidelines outlined, published for everybody to be able to see? I think there's some transparency concerns that we've heard from the OAG, and I'm going to turn to the OAG shortly, but what safeguards would be in place so that, you know, the public who's interested, whether because they are associated with a business that might want to apply or just because they are, you know, want to be watchdogs when it comes to consumer protection, will they be able to see insights in terms of what this process looks like, the application, et cetera, online? What do you anticipate that process looking like?
Well, we do anticipate that there will be a public comment period related to the rules that we create. And we know that a lot of what we've shared in our testimony and what we're proposing will need to be further fleshed out in rulemaking, and we're open and committed to doing that. As it relates to the overall application process, as outlined in Section 4 of the bill, we have a very tightly outlined application process that, as two of the council members referenced, there's been a lot of work and research done as to what we want to include in our regulatory sandbox. So one, the applicant would have to agree to be subject to the jurisdiction and regulatory oversight of the department, would have to provide the commissioner with adequate access to the applicant's records, would have to also provide an adequate understanding of the innovation, necessary personnel, financial, technical expertise, capital to test, while ensuring that consumers are protected. Applicants would also have to disclose any criminal convictions of key personnel and also provide a detailed description of the innovation, including a testing plan and a number of other things that have been outlined in Section 4 of the bill. Again, we recognize that there are concerns. We recognize that this concept is somewhat out of the box for the district, but we also recognize that it is essential that we are forward thinking about how we are looking at innovations as they are entering into the marketplace. A number of the examples that the Attorney General referenced are examples of scammers that do exist, bad actors that do exist in the financial services industry. But I would argue that none of those entities have been affiliated with the Sandbox. I think that the Sandbox has the necessary controls in place. Our Sandbox is very clear that any applicant that's admitted to our program would have to adhere to the district's consumer protection laws. That is not something that we are wavering on. That's not something that we are omitting. That is something that is necessary. And we know that the OAG's office has authority over those consumer protection laws. So I'm happy to flesh that out in more detail. I'm happy to have that conversation in the rulemaking process with the OAG, and also make sure that that process is public.
So let me ask about that. Let me give Benjamin Weissman an opportunity to perhaps expound upon some of the concerns that was raised in the testimony just provided. I know waivers are one of the things that came up. Let me start from this. Has DISB communicated with OAG about this legislation up until this point, or is this the first time you're hearing some of the concerns that OAG just expressed on the record this morning?
I would say that this is the first time that we're hearing about OAG's concerns, which is somewhat surprising. The Sandbox itself was created in December of 2019. The council met for the first time in 2019. We've had the last 2 years where the council and the department have been working on the Sandbox concept. We had a report that was issued in October of 2020. That report was shared with the council, and we introduced legislation in April of 2021. It wasn't until Friday that we heard that the OAG has concerns. I think overall that both OAG and the department have a shared goal of protecting consumers, and we're willing to work cooperatively with the OAG in ensuring that we're protecting consumers. We have been engaged with OAG in other areas, so we were surprised to hear about their concerns because this had not come up. We do believe that the legislation strikes the right balance between protecting consumers and also fostering innovation. And as I've stated before, the OAG's authority under the DC Consumer Protection Act is not impacted in any way by this legislation. And we're committed to working with the OAG to ensure that that stays in place, and that we also factor in some of their concerns during the rulemaking process.
Okay, well, let me just ask though, maybe just lay it out as a broad question to Ms. Weissman. Is there a fair, better way to legislate a financial sandbox program? I don't take from the OAG's testimony that the district can't get to a place where it has a solid financial sandbox program, but you do raise legitimate concerns about consumer protection. It doesn't sound like you were a member of the council, but is there a fair, better way to be able to roll out a program such as the one that is proposed here, if the legislation takes into consideration some of the things that you raised in your testimony? Does the OAG believe that there's a way to do this?
So I think your question raises a sort of a more fundamental question, Chairman, which is why are sandboxes preferable to what's possible without them? And I think OAG's position is that the current laws that are in place, the consumer protection laws, interest rate caps, fair lending laws, all serve very important purposes, and that trading those protections for the promise of innovation is just a bad deal. I think what we have seen in the sandboxes that have existed in other jurisdictions is that the benefits are really illusory. It's unclear if it has drawn innovative companies to those jurisdictions. That, there have only been 10 applicants in Arizona that have been through the sandbox. Some of the jurisdictions have failed to welcome any applicants. And more importantly, we have not seen any evidence that sandboxes have been shown to address the major financial issues facing the district's most vulnerable residents, many of which Commissioner Woods spoke about. We have one of the highest populations of unbanked and underbanked residents. We have low levels of financial literacy, and there's no evidence that the sandboxes have been used or work in ways to address those issues. In fact, it's been quite the opposite. The companies that have applied for sandboxes have been, in Arizona at the very least, have put forward products that the CFPB has recently flagged as problematic and risky, like buy now, pay later products, like income share agreement products. And so, in the district's view, trading the protections of the consumer protection laws for innovation or the promise of innovation, where there haven't been shown to be many benefits, is just not a good deal for district residents.
Well, let me ask you this though, because when you say trading the protections of our consumer protection laws for the sake of innovation, if there's a policy that lays out some way to be innovative in the financial technologies industry. But the protections and the ability of the OAG and other agencies to enforce against companies that run afoul of our laws and regulations still exist. Is this measure necessarily trading protections though, right? So let me just give you an example. You mentioned two companies, I think it was Opportunity Financial and Elevate Credit, that were using, it sounds like some predatory practices, and you all enforced against them, and it sounds like you did a great job there. I don't read the bill to suggest that it some way provides immunity against OAG enforcement or enforcement by any other agency if one of these companies runs afoul of the law or the regulations with respect to this measure. Are you suggesting, Mr. Weissman, that by relaxing certain regs or not enforcing certain regs would trade the consumer protections that currently exist such that you wouldn't have the ability to enforce?
So in our reading of the law, we think the law is written quite broadly. And in our reading of the law, it doesn't just allow the commissioner to waive district regulations, but also district statutes. So let me give you an example of how it would impact those that could potentially impact that type of litigation. The commissioner has broad authority to waive all district laws, including laws under Title 26. Chapter 9 of Title 26 governs money lenders, and under DC Code 26905, it provides that the maximum rate of interest charged by money lenders can't exceed the district's usury cap. So arguably, under our sort of reading of the law could be read that the commissioner could, for a financial product, waive the district's usury cap with respect to under Title 26. In that case, the district, which has the authority under the Consumer Protection Procedures Act to enforce the district's usury cap, would not be able to bring an enforcement action if the commissioner has waived that under the authority provided by this bill. So that's one example. Another example is Chapter 10 of Title 26 concerns money transmitters, where OAG has specific authority to enforce. And again, we think the bill is written broadly that the commissioner could waive certain statutory requirements from that chapter.
Okay. Do you disagree with the OAG's reading? Or I don't know if you have anybody else on your team, if you want to, Commissioner. I'd love to hear your perspective about the way that they read this. That is concerning to me. If in fact, the commissioner would have that sort of broad authority to waive not only regulations, but also provisions of our code, the way that was just described by Mr. Weissman.
I'll briefly respond, and then I'll ask my colleague Dana to chime in as well. I think the operative word that Ben emphasized was could. I think there's a difference in us being able to do something versus us as a department actually doing it. And we included the waiver provision for a reason. And we didn't want it to be too strict and too controlling, but it does allow us the opportunity to assess every applicant, every innovation, to determine what it is that we would actually waive. So it's not a blank check that we would just waive any and everything that an applicant is proposing. And so I think that's a misinterpretation. Again, I'm committed to working with the OAG's office to ensure that we can come to a place of understanding, a place of cooperation around what the program will look like moving forward, and making sure that we include certain aspects of their concerns in the rulemaking process. But I'll also defer to my colleague Dana to further expand.
Thank you, and good morning, Councilmember McDuffie. Thank you for the opportunity to testify on this important legislation. As Commissioner Woods just mentioned, the law the legislation does provide for waiver authority. As you can appreciate, as we sit here today, we don't know exactly what opportunities will come our way. And so the law is written, the legislation is written very broadly so that we can exercise the authority to waive various provisions. The issue, though, is we would not necessarily we would not exercise that authority in a way that harms consumers. As you know from your time as chair of the committee, we are dedicated to consumer protection at DISB. We student loans, we have a robust complaint section. Everything we do as the OAG, our goal is to make sure consumers are not harmed by anyone. So while we have the discretion to waive certain provisions of the law, at least the laws under the code, the Insurance Securities and Banking Code, not the Consumer Protection Act, we would not necessarily do that if we believe that it would harm consumers. And so we just ask that the council give Commissioner Woods and her team some discretion and have confidence that we would operate in a way that would not harm consumers.
I appreciate your testimony, both of you, Commissioner Woods and Mrs. Shepherd. But I don't know that either of you are going to be there, long enough where a scenario comes up and somebody just simply gets it wrong, or the intent behind the waiver might be obviously in the best interest of the city when it's made, but it could create a scenario that Mr. Wiseman lays out where a waiver is relied upon by some bad actor to seek shelter after they've done something that does harm consumers. And so would you all, by you, the commission, be opposed to a modification of this bill that would allow the OAG or some other relevant agency to approve a waiver before it happens? Or do you all think that is problematic? And if so, let me know why.
I would have reservations about allowing the OAG to approve any waiver that is granted to a Sandbox applicant. I think that might not be a workable solution. At the end of the day, my department, we're the chief financial regulatory agency. And it's important that, again, as my colleague Dana has shared, that we're entrusted to regulate. We do that on a regular basis. And I think that if we grant the OAG the authority to be able to approve any waivers, they would look at it from a very different lens. We're willing to provide that information to them, but to have them a part of the approval chain, I think would create some challenges for us. I do want to also add, and I do understand the OAG's points around financial scammers, but I do want to emphasize that it's highly unlikely for any financial fintech scammers to apply to a Sandbox in the district or elsewhere because of the protections and controls that are in place. You have to submit to our authority. You have to undergo a background check. You have to provide financial information, particularly if their goal is to cheat. It's highly unlikely that you'll have entities like the entities that Ben referenced in his testimony go through our Sandbox program.
All right. Let me ask this question to Mr. Weissman. Your testimony seems to take issue with the legislation as drafted, not really requiring the commission to provide sort of a reason or written justification for granting a waiver to a Sandbox applicant. Would a requirement that the commissioner provide a written decision regarding a waiver that is published, perhaps for a certain amount of time prior to it being approved, resolve your concerns in that regard, Mr. Weissman, or the OAG's concerns?
So I think there's a few, in part, it would resolve that specific concern with the specific bill, taking into consideration our general view on sandboxes as a sort of a principal matter. In addition to sort of a written justification, we would think that OAG is the chief legal officer in the district, and potentially other district agencies should be involved in this approval process. that it should be a framework that involves, the district as a whole. But with respect to the decision making and the transparency component, in addition to providing written justifications, we think that a more consumer protection oriented law to provide a sandbox would include in the statute factors that the commissioner must take into consideration when approving a sandbox applicant. So, for example, the CFPB's process, which we oppose to begin with, when they issue no action letters, there are 10 factors they have to consider. Those include the evidence that the actual product is going to provide a substantial benefit to consumers. They also have to consider whether the sort of the uncertainty of the regulations or the regulations that would be at play can be addressed through other regulatory means, not just through the sandbox process. So we would also encourage other factors the commissioner be required to consider, specific factors that are focused on ensuring that these products are not going to be harmful to consumers.
So let's do this rather than try to hash out, today during this hearing process. In your testimony, you mentioned the OAG's willingness to work with the committee on this, and I heard Commissioner Woods talk about her willingness to engage the OAG. I'd be interested, Ms. Weissman, if you could lay out the ways that the OAG believe this bill could be modified to protect district consumers, but allow the sort of innovation that I think the commission is seeking with this measure. So I would ask if you could provide an additional testimony or written the types of modifications that you believe would improve this bill such that it better protects district consumers and is more transparent in terms of some of the processes. I don't know if there's any follow-up that you would like to provide, Commissioner, just to shore up any points that came out here in the testimony or any of the folks who testified as public witnesses. I know the credit union, the two witnesses who were affiliated with the credit union industry raised some concerns as well about this bill and are on record in opposition to the bill. And so I think that would be helpful for the committee as we consider how to move forward or not with this measure. Either one of you want to add anything else to the record?
Mr. McDuffie, I would point out that as you're well aware of the abuses that we've seen in the past decade in the mortgage market, as well as in some predatory loans and whatnot, those are committed by national banks. I'm not so sure about credit unions, but certainly regulated, national banks are the ones that harm consumers in those instances. It's threatened the national economy when we talk about the mortgage crisis that we had. So this is not a sandbox. It's not a fintech issue. That's another hearing, another day.
No, I appreciate that, Mr. Shepherd. I also am mindful of OAG's testimony with respect to experience with Opportunity Financial and Elevate Credit. And maybe Commissioner Woods is absolutely right. Those are the types of companies that would never apply to a sandbox. But I think the concerns that the OAG laid out do warrant consideration in terms of the best way, if there is a best way to move forward with this type of measure and allow for some innovation in the fintech industry in the District of Columbia, but doing so in a way that protects consumers, is transparent so people understand what's happening and can raise concerns, perhaps before a waiver is granted or an application is approved. Maybe we can get there, maybe we can't, but I think it really warrants some further consideration and perhaps suggest modifications from the OAG and an opportunity for you all to respond so that the committee is best informed about this bill before we decide whether or not to proceed.
And thank you for that, Chairperson McDuffie. A couple of things. One, we're committed to following up with the list of all of the Sandbox council members for your awareness. We're also committed to working through some of these concerns with the OAG. I know that they reference things like lowering the transaction dollar amounts and other limits in terms of the pool of district residents, willing to work with them on that in the rulemaking process. I also just want to share so that you're aware and the rest of the committee that the department has been in close communication with a number of regulators from states that have sandboxes. As you know, we're part of the National Association for Insurance Commissioners. We've talked a lot about Arizona. The regulator for Arizona heads up one of the working groups focused on innovation. We're a member of that working group. We've also met extensively with Director Daniels in Arizona about their sandbox. We've met with their team. We fleshed out a lot of, questions that they've had or things that they've encountered as a result of implementing their sandbox, as well as speaking with the folks in Wyoming and some of the other states as well. And so, I just want to share that with you so that you're aware that we've done a lot of legwork on this, but we are fully committed to working with some of those concerns that the OAG has and also addressing any additional questions that the committee may have moving forward.
That's helpful, Commissioner Woods. I appreciate you providing that for the record. Is there anything else that you'd like to provide for the record before we move to the next measure on our agenda?
I just want to encourage the committee to move forward with the legislation, giving some of the amendments that we've discussed here today. We think that it's an important part of spurring innovation here in the district's economy, and we look forward to working with all parties to ensure that we do just that.
Thank you. I'm going to turn to Mr. Weissman. Anything else you'd like to add to the record before we move on to our next measure on our agenda?
Nothing, Your Honor, beyond nothing, Chairman, beyond, this has just been a long-standing position of OAG since 2018. But thank you for the opportunity to discuss today, and we will work with the commissioner and get you the information that you've requested. Thank you.
Thank you both so much. Appreciate it. And I will note for the record that we've been joined by Ward 7 council member and member of the committee, Vincent Gray. And just in time for us to turn to our next measure on our agenda, which is Bill 24-643, the East Capitol Gateway Eminent Domain Authority Act of 2022. This legislation was introduced by the mayor to resolve the lack of progress on the project originally known as Capitol Gateway. The site is in Ward 7 at the intersection of East Capitol and 58th Street Northeast. And I want to also include in my remarks an acknowledgement that there's a consensus about certain facts and issues surrounding this project, I believe. There's been a historical dearth of retail establishments, especially grocery stores and other healthy food options in this area on the east end of our city. The result has been an over-reliance on corner stores and fast food facilities that do not always offer the least expensive or best quality food and items for families. And I think indeed there's only a handful of full-service grocery stores east of the river, clearly inequitable for the predominantly Black residents in Wards 7 and 8. That clearly has a deleterious impact on the health of those residents, which I think is intolerable. And I appreciate the efforts of Councilmember Gray, as well as Ward 8 Councilmember Trayon White and others on the council, including Ward 3 Councilmember Mary Che, to work with my colleagues to address some of these issues. And I think this measure is another step, small but significant step towards a solution. And so I think the history goes back a decade when the developer there was obligated to sublet jointly owned with the DC Housing Authority to a retail tenant, full service grocery store, I believe. And the developer then announced a retail agreement that never came to fruition. And so I think that's an important fact to outline as well. However, it's my understanding that Walmart has continued to make ground lease payments of more than $1 million annually to the developer. According to the mayor, absent intervention, this will constitute the status quo until 2037, which is some time from now. I believe that we all can agree, hopefully, that that's unacceptable. And so the mayor's proposing in this measure to acquire this project site through eminent domain. We'll hear much more detail shortly from a representative with the Office of the Deputy Mayor for Planning and Economic Development. I'm going to listen intently to his testimony and ask all witnesses about potential alternatives so that we have a clear path forward. And I want to turn to Ward 7 Councilmember Vincent Gray, who's been a champion for these issues, to give an opportunity for a brief opening statement before we call up any public witnesses to testify. Councilmember Gray, thanks for joining.
Thank you very much, Mr. Chairman. I want to thank you for hosting this hearing. This is such an important issue for the people of Ward 7. As you've acknowledged, we've been without retail options. I think if you go back and look, we've had a couple of grocery stores on the in Ward 7, and what we're trying to do, especially with this opportunity that's being created, is to create more opportunities for people who live in Ward 7, be able to have a chance to be able to shop. I want to thank you for, you got another bill that you've worked on as well, and that is the issue with liquor stores, and I know that won't be coming up today, but I want to thank you for your work in order to make that happen. But to be able to create an eminent domain option for something that is now, as you've already indicated, Mr. Chairman, should have been years ago, should have been done. So finally, it's here. I'm happy to be able to be here and be a part of the hearing, Mr. Chairman, and so I'm delighted to be able to continue to work with you to try to make this happen so people will have a chance in Ward 7 that they haven't had before.
Thank you, Councilmember Gray, for your statement. I'm going to turn now. I know there are about 8 people who had previously signed up to testify. I don't believe they're all present, so we'll make a call and we'll go with the public witnesses who are present here this morning. I thank them for their presence and providing testimony to the committee. I see Senta Keeling, Renee Carter, Patricia Stamper, Vince Van, who's an ANC Commissioner 7C03, Santana Gale, Antoine Holmes, I see is present, who's Chair ANC 7C, Marsha Huff, and Jamel Sanders. And so I'm going to start with, I see Commissioner Holmes. Well, actually, I see, I'm going to try to do this in the order that you signed up, if that's possible. So I'll go first to Commissioner Van. And good morning to you, and thank you for being here this morning. You can begin your testimony.
Thank you, Councilmember Duffy. Thank you also to Councilmember Gray for the work that you all are doing in regards to this critical matter. I was stated earlier, but I want to state it again for the record, that there are currently 79 full-service grocery stores in the district, 3 east of the river. 79 full-service grocery stores in the district, 3 east of the river. However, when we look at crime, we see crime being in Ward 7, being in Ward 8. There's a correlation between crime, between the lack of food, lack of resources. So when we talk about the need for a grocery store in Ward 7, particularly in these areas, this is not just a matter of a accessory for the community, but this is a matter of safety. This is a matter of how do we make our communities better. Young people have access to liquor stores, have access to vapes and terrible foods for their bodies before they go to school. after they go to school, but they don't have access to fresh fruits. They can't get an apple. They can't get a fruit. They can't get vegetables. Just the simple things that you would think that a young child should be able to eat. However, again, they could get access to these things. And I think this is so critical that we move forward now. We don't wait. You know, you all stated it's been 20 years that we've been fighting for this, but yet we see grocery stores across the river that are coming just now. New Wegmans coming on Wisconsin. There's so many different grocery stores that are coming. But my concern is, as we continue to talk about this, it is my hope that after elections are finished, after everyone has stopped, they're done kissing the babies and making these promises, that we're not having this oversight hearing again a year from now without any traction. I live right next to this lot, and I've been seeing it vacant for so long. So it's my hope that this is not just a moment for voters to gain voters, but this is a moment that we see that we're actively going to push forth to bring in a grocery store in the community. And as I have 40 seconds left, I also say this: when we do get this grocery store, please make sure that we keep this grocery store up to par. We had the Safeway on Minnesota Avenue, and that Safeway is not up to par. It hasn't been remodeled. It hasn't had upkeep. It's understaffed. Let's make sure that if we're going to put grocery stores in east of the river, that those grocery stores look just like grocery stores on Wisconsin Avenue, look just like grocery stores on Pennsylvania Avenue, that these grocery stores east of the river are not just left off, but our produce are fresh, our workers have great salaries, and also that the management of these stores are up to par. Thank you for your time, and thank you for the work that you both are doing.
Thank you for your testimony, Commissioner. Just to be clear, Commissioner, you are testifying in your official capacity as Commissioner of 7C03?
Yes, sir.
Okay, thank you for that. I'm going to turn next to Antoine Holmes, who's chair of ANC 7C. And good morning to you. You can begin your testimony.
Good morning, everyone. Good morning, Chairperson, Duffy, and committee members. I want to go ahead and state that, of course, Capital Marketplace does reside in ANC 7C, as Commissioner Van has stated, and that ANC 7C, we support the East Capitol Gateway Eminent Domain Authority Emergency Declaration Resolution of 22 and the proposed contracts for this assignments of sublease of property from Walmart. The development of this site is critical for the residents of 7C. We've been eager to see this project move forward. The need for a grocery store in the community has already been well documented. So, and we were severely disappointed when Walmart did not move forward with plans to anchor the Capital Gateway Marketplace. Community members have voiced their displeasure during our commission meetings for many years about the delay of this project and delivering what's been promised. And at this point, we're supporting this because we want to make sure it's time that the promise of a grocery store is being delivered in Ward 7. And so as far as the community, we're concerned about the redevelopment of this project in terms of the vacant lot could be stalled for the future. Again, we support this amendment, and we want to see and to continue to work with DMPED and have economic and outreach to be able to produce not just the grocery store, but all the other parts that need to be on that site. I'll get back the rest of my minutes. Thank you for your leadership on moving forward with this bill, and I'm available for questions.
And thank you for your testimony, Commissioner Holmes. I'm going to turn next to Marsha Huff, and good morning to you.
Good morning, Councilmember McDuffie. Good morning, Councilmember Gray and members of the committee. Thank you for the opportunity to speak today. My name is Marcia Huff, and I live in the Marshall Heights community of Ward 7 with my husband and 2 children. I'm here to speak on the East Capitol Gateway Eminent Domain Authority Act of 2022. We purchased our home in 2013. We were glad to hear about the Capitol Gateway Marketplace, a development that included a grocery store, restaurants, and other retail. There was even talk of a gym. Therefore, we were extremely disappointed when Walmart pulled out and the development plan halted. As a Ward 7 resident, me and others feel neglected by the city's leadership. It angers me to see Target, Walmart, Wegmans, restaurants, gyms, other stores open throughout the city and none in my own community. The new Skyline development is awesome, but it isn't particularly accessible to those who don't drive, especially the elderly, disabled, or people who are metro dependent. And consequently, doesn't mean much to a sizable number of Ward 7 residents. My family is fortunate. For right now, we're financially stable. My husband and I both have cars and we can travel to grocery stores without issue. But this isn't the case for many in my community. It's a long and rough trip, especially with children, to the grocery store and back. It's exhausting. Some will have to take 2 buses, walking with heavy groceries, and more than likely to a substandard store that is crowded and where you need to closely monitor expiration dates. The sad truth is that many residents have given up hope because year after year, decade after decade, it's the same refrain. Help is on the way. But all we see is our neighboring wards receiving the VIP treatment while we're still clamoring for the necessities. For nearly 10 years, I've worked at a DC nonprofit, the Young Women's Project, that builds the leadership and power of youth to shape DC policies and institutions to expand rights and opportunities. Every week, I facilitate a group of students from Bard, Eastern, Ron Brown, and Woodson at the Capitol View Library. A few weeks ago, I led a session on the social determinants of health, and we discussed how our physical environment and lack of access to fresh, nutrient-dense food can have a major negative impact on our mental, physical, and emotional health. We talked about how there's so many carryouts and liquor stores, but so few grocery stores and restaurants. It was difficult to talk to these young people, amazing young people, to talk about the factors that are at play that are actually working to destroy them. These messages that are conveying that they are inferior and unworthy just because they live in a certain zip code. Thankfully, they're not going to be destroyed, and all of them are working to improve their schools and the community. I love my community. Our families deserve fresh food, retail, entertainment, and fitness. This legislation is a step in the right direction, but we have a long way to go. Please pass this bill as a sign of goodwill towards the citizens of Ward 7. We are thirsty for change. Thank you.
And thank you for your testimony. We're going to turn to our final witness on this particular panel, and that's Aaron Parrott. Good morning to you. You can begin your testimony.
Good morning. Thank you for having me. Greetings, Councilmember McDuffie and Councilmember Gray. My name is Aaron Parrott, and I live in Capitol View in Ward 7. I'm here today in support of Bill 24-643, the East Capitol Gateway Eminent Domain Authority Act of 2022. This bill and the resulting development will have a direct, substantive, and positive benefit to our community. A grocery store is a public necessity and will enrich the lives of the people who live here. Development on this property has been stalled since 2016, but its origins stretch all the way back to 2000, over 20 years ago. The development agreement contains no milestones, no termination options, and the developer receives $1.3 million a year to do nothing. Without the use of eminent domain, there is no development in sight for the next 15 years. Our community is well over a half mile from any grocery store, has low rates of car access, and a high poverty rate, 3 factors that categorize an area as a food desert. In this context, the development of a grocery store at East Capitol Gateway is a necessity. With this in mind, please move this legislation forward. Thank you for allowing me to speak today, and I'm happy to answer any questions.
Thank you for your testimony. I do want to ask Commissioner Holmes, I don't think that we have your written testimony. So if you could provide that to the committee, we would greatly appreciate it. I don't know if the ANC has done an official resolution. If so, we'd love to have that as well. I'm going to turn to Councilmember Gray for a round of questions. Staff, if we can do 7 minutes.
Yeah, I really want to echo the sentiments of Commissioner Van and Commissioner Mr. Chair, Antoine Holmes, and also Ms. Huff, as well as you, Mr. Parrott. Thank you for being here today to testify. This has been a long time coming, and it's going to happen this time. I'm hopeful that the chairman is with us, and I'm hopeful that, of course, the mayor is with us. So we'll hear from her representative shortly, to Mr. Chairman. So I think this is a moment in time that has come finally. I mean, with the Walmart situation, that was a huge disappointment. With them pulling out, with the developer who was working with us, he pulled out. And now we've got an opportunity, I think, to really create the kind of retail food opportunities that just have not existed heretofore. So I am delighted that this is coming to pass, and look forward, Mr. Chairman, to being able to vote yes on this bill. Thank you, Mr. Chairman.
Thank you all. Let me ask this though, for the folks who are here. Again, I thank you for your testimony, but how far do you all have to travel to access a full service grocery store? I'm going to start with the commissioners.
Again, I think everybody will tell you that. You definitely need to take a car or some type of transportation. Again, if I find that the stuff isn't up to par at the local Safeway, then I will be driving. But right now, it can be driving across town. It can be driving out of the city to Maryland because we're at the edge of the city. So it's very easy for us to go to the Giant over there or to go to some of the other stores located right outside of the district because it's quicker, honestly. Again, it's definitely an issue of if we don't have transportation that is just people being able to go there and reach themselves. I've seen people take Uber rides there. We've given the East of River when they had the transit to rail and they used to transit to grocery store. There's been programs out there prior to Uber being out there. People would just pay people to go to the grocery store to pick things up. So it's a real issue, and we do have to, for those who can drive, do drive to go get groceries.
Anybody else want to provide any feedback? Marcia Huff or Ann Parrott? Or
Yeah, I definitely try to avoid the Safeway, and it's just too much of a toss up about the food. I mean, mostly we go to the Giant that's off Silver Hill Road, or sometimes my kids go to Two Rivers, so we'll go to the Aldi over off 17th. But like you said, you need a car. You need a car. You know, when I was, forever ago, when I was single and didn't have a car, taking groceries for one person was quite the task. And I can't imagine having my two children who are 4 and 8 with me as I got groceries, navigated the bus, and just walked with them. And it's not feasible and it's not fair. And I'm floored with the 79 in the city and 3 for us. So that's actually worse than I thought. But if you don't have a car, you're pretty much out of luck to get your groceries.
And when you reference the Safeway, just to be clear for the record, for those who are unfamiliar with the area and around this site, which Safeway are you referencing?
It's the one that's right at the corner of Minnesota Avenue and Benning Road. There's a CVS there. I mean, if you go there, the parking lot is in disrepair. There's trash everywhere. It's just a bad situation. So not only is it like our only close grocery store, but it's really bad.
And the grocery store that was on Central Avenue, for anybody who wants to provide some insights to the committee about that.
The one the Safeway that was there, or the
there
one?
Was a Safeway. Yeah.
There was a Safeway, and it closed a few years ago. It's been a while because there's a Planet Fitness there. It was also terrible. It was dark. It was really bad. There is a new grocery store in that plaza. It's called Good. I can't think of the full name. And it's nice and the people are nice there, but it's significant. It's pretty expensive, understandably, because they're a smaller store, but and it's still a hike. You still need a car to get there.
And I wanted to make sure you all put that on the record. I'm very familiar with the area. In fact, used to live right around the corner from the site. And so I thought it was important to provide context for folks who are not as familiar, who might be listening at home, or those who are looking at this issue and deciding where they want to end up in terms of support or opposition. I have a full context of the challenges that are facing residents who live in that area. It is indeed a challenge to access healthy foods if you live in and around the community where this site is proposed. And so I do appreciate you all putting that on the record for the day. I want to make sure I'm pronouncing, Ms. Huff, your name correctly. Your first name for the record is?
It's Marcia.
Okay.
Yep.
Okay.
Thank you.
Anybody else, any one of the public witnesses want to add anything to the record before we turn to our government witness?
I agree with everyone's sentiments that's already been shared. I commute by bicycle, and so does my partner, so we're a bit different. And we are able to buy in smaller quantities more frequently, which is how we have the ability to just load everything on what we're carrying on our bicycle. I work at 1st and 8th Street in that area where there's 5 grocery stores within walking distance. And so that's where I do my shopping after work or before work and then carry it home with me. But obviously, since I don't have a car, it makes it a little difficult to do it in larger quantities. So we do it smaller and more frequently. But I think just that stark contrast to an area that has so many options. And we don't have one within, Safeway from our place is about 2 miles away. So it's just very different.
I appreciate you adding that to the record. I'm familiar with the area where you work, and there are a number of grocery stores, almost feels like in a stone's throw of one another. And so I think it's important that we have similar opportunities to access healthy foods in and around Marshall Heights and parts of Ward 7 and 8. Ms. Huff, I'll tell you, I noticed your testimony. We talked about feeling neglected by the city's leadership. I will tell you, it's not for want of trying. Before the pandemic, Councilmember Gray and I would travel to ICSC in Las Vegas every year. We would engage with grocery stores. We would make every effort to try to attract them. Obviously, as mayor, there were further efforts that Mr. Gray made, and we keep trying. And so this is yet another attempt. And please know that it's my hope as chair of this committee to work with you and Councilmember Gray, with the mayor and the deputy mayor to see this through and make this happen, because there is an extreme need for you all in that area of the city. I think everybody recognizes. It's just a matter of how we get there. So I really do appreciate you all taking the time to testify. I'll note for the record, there's several other residents who provided written testimony, and their written testimony will be incorporated into the record for this measure, and will be available for the consideration of my colleagues when we consider this measure. So thank you for your testimony.
Mr. Chairman.
Sure. Mr. Gray?
Mr. Chairman, just wanted to mention one other thing. I appreciate you mentioning the Central Avenue. That isn't even in the District of Columbia, Mr. Chairman. And it's just a hardship that's imposed upon people who live in Ward 7 to go all the way to Prince George's County in order to be able to be served in a situation. So with this eminent domain being exercised, we now have an opportunity to create opportunities that just had not been there before, Mr. Chairman. So thank you very much for holding this hearing, and thank you for the work that you're doing on this, okay?
Absolutely. Thank you all. We're going to turn next to our government witness, and it's Timothy White, who is present with us. He's Executive Director for Equitable Development within the Office of the Deputy Mayor for Planning and Economic Development. Good morning to you, Mr. White. Thanks for joining us. You can begin your testimony whenever you're ready.
Good morning, Chairman McDuffie, members, staff of the Committee on Business and Economic Development. Again, my name is Timothy White. I'm the Executive Director of Equitable Development with the Office of the Deputy Mayor for Planning and Economic Development, DMPED. And I am pleased to provide testimony in support of Bill 24-643, the East Capitol Gateway Eminent Domain Authority Act of 2022. This legislation will authorize the acquisition through the exercise of eminent domain of certain real property known as East Capitol Gateway, located at the intersection of East Capitol Street and 58th Street Northeast in Ward 7. I would like to note that DMPED will be submitting additional materials for the hearing record along with my written testimony, including a condemnation justification report that provides additional details and background information regarding Capitol Gateway. As noted, communities east of the river, including areas along East Capitol Street corridor, have historically been underserved regarding retail options, particularly by access to healthy food options. While a number of grocery stores, as was talked about, have grown across the district in recent years, the growth has not been evenly distributed across all of the neighborhoods and areas in the city. Neighborhoods that continue to lack healthy food options are heavily concentrated in Ward 7 and 8. Currently, there are 4 existing full-service grocery stores in Ward 7 and 8, serving approximately 160,000 residents, 92% of whom are African-American. And this is in stark contrast with Ward 6 that has, with just across the river, having 15 full-service grocery stores. And so with few options, community members are forced to rely on corner stores and fast food restaurants that offer low cost and unhealthy food options. This includes convenience stores, liquor stores, carryouts, and fast food establishments in districts areas that have that are less food secure areas. And so, as pointed out by the DC Health Equity Report in 2018, food insecurity and poverty are associated with costly health conditions and have a direct and indirect impacts on the health and well-being. In Ward 7 and 8, there have been significantly higher rates of diet-related diseases such as obesity, diabetes, high blood pressure, and high cholesterol. Nearly 3/4 of the population are considered to be overweight or obese. Additionally, rates of asthma are also well above average at over 15% for both wards. And so in food insecure residents in areas of low healthy food access are forced to rely on low quality foods, resulting in malnutrition and some of the diseases that were just mentioned. And also mentioned proximity to foods to a full service grocery store is not just a matter of convenience, but again, it's a matter of health and well-being. And so studies have shown that areas with high access to convenience stores and corner stores have a high prevalence of obesity. And so the varying distribution of full service grocery stores in the district has a significant economic, social, and health impacts, and escalates the need for a new full service grocery store in especially this part of Ward 7. And so the mayor and DIMPED remain committed to expanding food access in all the neighborhoods that are of need. And so in this particular project, the Capitol Gateway Marketplace development represents a long anticipated commercial component of the project of 40 acres of mixed use redevelopment of the District of Columbia Housing Authority, DCHA public housing project that is funded in part through the federal Home Hope 6 grant. In 2012, DCHA entered into a ground lease for the site with a special purpose entity that is owned by a subsidiary of DCHA and the affiliate of A&R Development, which I'll refer to as the developer. And under the terms of the ground lease, the developer would enter into a sublease would sublease the site to a full service grocery store and construct and operate it for an initial term of 20 years. And in 2012, the developer announced that Walmart would be that anchor tenant to develop an over 130,000 square foot supercenter. The master plan of Capitol Gateway revitalization effort envisioned a mixed use development that would replace a large area of public housing with a mix of uses, housing types, and families of various income levels. To date, the senior housing and residential development with single family detached, duplexes, row homes have all been completed and occupied. The final phase, known as Capitol Gateway Marketplace, contemplated Walmart Supercenter, which included a desired full service grocery store component, mixed use development with over 280 residential units and retail space, a 21,900 square foot office building, and a 8,880 square foot sit down restaurant. Unfortunately, that final phase of development was stalled in 2016 when Walmart canceled plans to open the store and be the anchor tenant of the project. And following that decision, the developer made it clear that they were unwilling to move forward with this critical development project. And in a letter to DCHA dated September 19th, 2016, A&R Development communicated its plans to mothball the project and not expend additional resources in development activities and will prepare the site for long-term inactivity. And so a copy of that full letter will also be included in with the report that we will be sharing to the committee. The developer entered into the ground lease with Walmart on September 12th of 2012, which is set to expire in June of 2037. And pursuant to the terms of that lease, Walmart is obligated to make annual lease payments to the developer of $1.3 million through the end of the lease term. And so to date, the developer has received approximately $6 million related to those lease payments since July 1st of 2017. And obviously projections indicate that joint venture is set to receive even more over the remaining 15 years of that lease. Given the anticipated cash flow guaranteed on the remaining term of the project or remaining term of the lease, the developer has minimal incentive to advance the Capital Gateway development. Additionally, with only 15 years remaining on the lease, the district is unlikely to secure a large-scale grocery store with only the ability to do a lease assignment. With the existing developer unwilling or unable to advance the project, absent intervention from the district, residents near Capital Gateway will continue to be robbed of the right to a full-service grocery store until 2037, nearly 40 years after the project started. And so the proposed Capital Gateway project, in addition to improving access to nutritional foods, will generate significant economic benefits to Ward 7 and surrounding communities, Wards 5, 6, and 8, including creating jobs, opportunities for residents, and generating additional tax revenue for the district. Based on the district's economic impact model using the 2013 design that was approved, during the construction phase, the project is estimated to generate 150 direct and secondary jobs in the region, with district residents accounting for at least 51% of those jobs, or 77 full-time equivalent jobs. The project would yield over $550,000 in local tax receipts during the construction phase just alone. The annual ongoing economic impact of the development, which represents a stabilized year of operation, amounts for an estimated 241 full-time equivalent jobs and about 23 million in gross expenditures. It will also have 2.7 million in local labor income and 1.4 million in annual district tax receipts. And so a detailed local economic impact during the construction phase, as well as the annual ongoing impacts, will also be included in the condemnation justification. And so the need for a new full-service grocery store in Ward 7 is obviously urgent. The food access is a critical social determinant of health, and it is in the public's interest to address that where it is lacking. And so the delivery of a new full-service grocery store at the Capital Gateway Marketplace would put more than 10,700 district residents within a mile of a grocery store that are not currently meeting that. DIMPED has received strong interest for the site from grocery store operators. However, a signed commitment cannot be secured until the project restarts. It's unacceptable how long this project has been allowed to delay. And given the developer's unwillingness to move the project forward, the mayor's ability to use eminent domain authority is a critical step to get a new full-service grocery store in this part of Ward 7. I would like to thank the committee for taking the time to hold this hearing. And I also like to acknowledge the invaluable support that Councilmember Gray and his staff has given us to this point. This concludes my testimony, and I look forward to answering any questions you may have.
Thank you for your testimony, Mr. White. I'm going to turn, before I ask my questions, I'm going to turn around first to Councilmember Gray.
Thank you. Thank you very much, Mr. Chairman. I want to thank you, Mr. White, for the work that you do and for your testimony today. I want to add my appreciation also to Dr. Nesbitt, who's our health director. She submitted a letter as well to underscore the health importance of this opportunity that will be created. So I want to thank Dr. Nesbitt, your colleague, and I want to thank you, Mr. White, for the work that you do every day. I appreciate working with you, and I appreciate especially working with you on this particular project. So thanks for being here and testifying today. We just have desperate needs. I don't know how to put it anymore. You've stated it well. Others have stated it well. it really is a desperate situation that we cannot allow to continue to exist in the District of Columbia. And this is an opportunity to be able to address this problem in a forthright way, in an earnest way. And it's just shameful that we would allow something like this to continue to exist in the District of Columbia. So thank you and DIMPED and the folks who are associated with leading DIMPED as well. And also thank you, Dr. Nesbitt, for the work that you have done to make the case for how important this is for the future of our children and our families who live in Ward 7. So I can't thank you enough anymore for your testimony today. So thank you, Mr. White, for everything. Thank you so much. I appreciate it. And thank you, Mr. Chairman, for giving us an opportunity to help make the case, which we thought we had made a number of years ago. But obviously, it had fallen upon deaf ears far too long. And now maybe we are at the threshold of being able to exercise the opportunity to be able to get a grocery store that people richly deserve. So thank you again, Mr. White. Thank you, Mr. Chairman, for your leadership on this, okay?
Thank you so much, Mr. Gray. Ms. White, let me ask some questions about the measure. You provided some pretty extensive testimony, but I want to sort of just go down and ask a few questions. So you talked some about witnesses, including two ANCs, talk about ways in which, and Councilmember Gray as well, ways in which the communities around this area are underserved in terms of retail options and access to healthy foods. But I want to give you an opportunity to briefly talk about that so that the record is clear. How are they underserved currently in this area? Do they have access to healthy foods if they live in and around the area of this site, Marshall Heights?
So to answer, well, first, let me make sure, thank you again, and thank you, Councilmember Gray. I didn't want to interrupt him, but I want to thank him as well, as they've been really great working with them on this. And regarding the answer to your question there, as you mentioned that, you know, of the 10,700 residents that will now be within a mile of a grocery store, they aren't right now. And so to say that they are underserved, I think is a very accurate statement, because they as the residents have pointed out, they need to travel by vehicle to get there. And right now that access is very limited. And so that's what drives the need for us to make this happen with this particular project specifically.
And who actually controls this parcel today?
Mm-hmm. Great question. These parcels are owned by the housing authority, but they are controlled through a ground lease by a special purpose entity that is owned by affiliate of housing authority, but it is managed by A&R Development.
And it's done, or at least it's controlled through a joint venture?
Yes.
Okay, and has that joint venture made any efforts to develop this site, to your knowledge?
To my knowledge, not since 2016, when they said they were preparing the site for long-term inactivity.
Okay. And they said you said long-term inactivity, just to be clear.
Correct. They made a commitment to prepare the site for long-term inactivity in 2016, and they have held up to that commitment.
Okay, which means that, you know, that inactivity could go on for a really long time and allow this site to be undeveloped, correct?
Correct. So we believe that, you know, with the lack of incentive to move it forward with the rent payments that are being collected, we don't see that this project would move forward before June of 2037 if no action takes place.
And June 2037 is when the ground lease would actually end?
Yes, that's the end of the first term of the Walmart lease.
Okay, and how much is the joint venture being paid under the terms of the current lease with Walmart?
$1.3 million a year in monthly payment.
sounds like it's not much of an incentive for them to do anything except sit back and collect that money.
They collect that money regardless of any actions that are taken.
And so let's just talk about the public purposes behind this measure. Once developed, as you all would like to see done, that includes DIMPED, the mayor, obviously residents, Ward 7 councilman. I think a lot of folks would like to see this site develop. But what specific public purposes would it serve in terms of the district?
Yeah, so for the district right now, our priority is addressing food justice. That's the focal point of getting a grocery store there. We do recognize that there is a housing opportunity, and at a point when we move forward with the food access issue that needs to be resolved, we plan on getting community input to understand where they still align with the 2013 design, and at which point we would use our 10801 disposition authority to work on that.
Okay, and if you could, Mr. White, describe the conditions of the site today. What does it look like if I were a resident over there and had to live near it or drive past it? How would you describe the conditions of the site?
I would describe the conditions of the site as a fence that needs to be a chain link fence that needs to be some work done on it to make sure it's up to par. A site where the grass, as it's going to start warming up, it will start to be overgrown. A site that has been known for illegal dumping, where the chain is regularly broken, and people go and dump over there. And so now what you will probably see is that at least the portion that the district has control over, that the trash that has sat there for multiple years or months that I see every morning when I drive by is no longer there. And so we're able to keep that a little bit better. But in terms of the site itself, because the district does not have control over it, you will see that some of the fencing and some of the areas of that site will continue to deteriorate.
So it sounds like a part of this process, and I think one of the benefits to the district and its residents would be to remove what you describe as some really unsafe and unsanitary conditions at the site.
Correct.
And that's in addition to just being an eyesore and potentially a nuisance to the folks who are in and around that area.
Correct.
You talked about it, but I think it bears repeating. What kinds of economic opportunities would flow from the eminent domain in this site and in the eventual development of the site?
Again, just our analysis based upon the 2013 design, we see that there will be an opportunity for 150 jobs during the construction phase and 241 jobs ongoing annually with the development. And in addition to that, we're looking at over $500,000 in annual tax revenue. And so the resources that the district and the community are losing out on are fairly significant.
Okay, and if the mayor isn't granted the authority to exercise eminent domain through this permanent measure, what do you see as likely to happen with that site, if anything?
Because of the fact that there are no obligations, there's no right to terminate in any of these agreements. There's nothing in any of the agreements that can compel anyone to do anything. As we mentioned before, it looks like this site would sit until 2037.
Okay. All right, I'm coming toward the end of my questions. Let me just run down for a moment. Do you have a timeline you might be able to share in terms of like what the process looks like? I know we've passed emergency legislation already. This is permanent legislation, but give me a sense of what the timeline looks like.
I can lay out what the process looks like. The timeline is vague. So this, with this eminent domain process, and just for the record, I obviously, I just want to, but for the public, eminent domain is where the government has the power to take property from a private, takes private property for public use for just compensation. And so just a summary of the steps with this particular, prior to filing with the courts, the district would need to coordinate with the housing authority and provide a good faith offer, at which point the housing authority would then accept that offer, would consult whether or not they want to accept that offer with potentially their partners and their board. The district would like it to be friendly condemnation. So that would mean that they would accept that and agree not to contest it. And then the district would file with the courts in a domain action where the just compensation would be provided to the court, and at which in exchange the district would get control of the property. Concurrently after that, the Attorney General's office would continue to work for a financial resolution with the courts. That will obviously be, I would say, easier if it isn't contested. But concurrently with that, the district would then have the ability to move forward on this project, similar to what folks have probably seen with the South Capitol Street Bridge, where they're still working through those things in the courts today. But I can drive across that bridge heading here into work now.
And I appreciate that. And I'm coming to the end of my questions, but you've already pretty thoroughly described in response to my questions the public purpose for this site. But it is the intent of the deputy mayor and sister agencies to exercise eminent domain consistent with laws described in DC code and provide just compensation in this process, correct?
Correct.
When's the last time there's been appraisal done for this site, to your knowledge?
We're actually in the process of completing one right now as we speak. And so we're working through that to get a final number that is an appraisal that is the most current. So we'll have that here in a couple of weeks.
Okay, and has the executive already identified funds for this process, and how much has been allocated for this?
We plan to use the food.
Strike the second half of that question, but I want to know if you all have identified funds.
Yes, we have identified funds. We plan to use the Food Access Fund to support this project.
Okay, and so are the funds sufficient in your estimation to be able to exercise eminent domain and provide just compensation?
Yes.
Okay. All right. Mr. Gray, do you have any further questions?
Chairman?
Yes. Do you have any further?
I would just want to add one thing, if it's okay, Mr. Chairman, and that is Skyland eminent domain was exercised with Skyland in Ward 7, which now is home to restaurants, to a grocery store, and we're trying to bring the same opportunity to what Mr. White described in his testimony, and that is to people who just don't have these opportunities available to them, Mr. Chairman. So thank you for holding this hearing today, and thank you for giving us an opportunity to address the desperate needs of people in Ward 7, who I know will be thankful if this legislation is passed, and they will be able to see a grocery store coming to pass where there had not been anything heretofore. My last question would be Mr. White, in working with DMPED and working through with DMPED, is there any entity at this point that has expressed an interest to put a grocery store there on East Capitol Street?
Yeah, as I mentioned, it's the site on a major thoroughfare right there at the Metro. We've had multiple entities that are interested in moving forward with to open a grocery store at this site, and some stronger than others. But the reality is, until we get this agreement done, we can't work with them to do anything at this point.
Understood. Thank you, Mr. Chairman.
Thank you, Councilmember Gray. And Councilmember Gray actually anticipated the last question I was going to ask about the grocery store and just the level of interest. I guess my final question would be, how's your offices, how has DMPED been able to engage the community around this. You heard the level of interest expressed by two ANC commissioners and other residents around that area. As I mentioned earlier, there's several other residents who submitted written testimony for the record. What have you heard in terms of feedback, in terms of interest by the community of trying to proceed with a grocery store? And I say that in the context of what I think residents expressed clearly is frustration over the number of years of not being able to get access to healthy food at that site or anywhere in that proximity.
Yes, there's been really great conversations with the civic associations and the ANCs that are around the site, and they really want a grocery store. I think the witnesses today just echo what we heard and from all of the different organizations, that folks want a grocery store. They want a grocery store now. They also want a sit-down restaurant as well. And so, you know, that we've heard that very loud and clear. And so we look forward to continuing those conversations and getting this happening as quickly as possible.
Okay, I appreciate it. There being no further questions right now on this issue or this measure. We're gonna thank you, Mr. White, and then proceed to our final measure that we have on the agenda for today. And that is that's Bill 24-71, the Pension Exclusion Restoration and Expansion Act of 2021. This legislation proposes to amend two sections of the DC Code to provide tax benefits for retired district government, federal and military employees, and district taxpayers who pay long-term care insurance premiums while itemizing deductions. The first provision seeks to restore and expand a historical benefit that was replaced in 2015 as recommended by the DC Tax Revision Commission. Before then, there was a $3,000 exclusion from gross income for those aforementioned employees ages 62 or older receiving government pensions or military retire pay or annuities. This bill proposes to restore and increase that exclusion to $10,000 for those 62 and 63 and to $20,000 for those 64 years of age and older. The second provision also seeks to restore a historical exemption repealed in 2015 at the recommendation of the Tax Revision Commission. This would allow, as was done previously, a $500 deduction for long-term care insurance premiums. I look forward to hearing further details from some of our witnesses who are being transitioned currently. And importantly, the financial impact on both the taxpayers and the district should either of these provisions be approved. And I'm going to give about 5 minutes or so. There are a number of witnesses who need to be transitioned over. So let's give staff about 5 minutes, Mr. Gray, just for planning purposes, the opportunity to staff to transition folks over. We'll be back shortly. Somebody's got a lot of feedback coming into the computer. If staff can help mute this person, in case they don't mute themselves. All righty. We're gonna turn to our first panel of public witnesses, and I'm gonna call them in the order in which they appear on the agenda. Actually, you know what? Maybe it was somebody who was inadvertently left off, which is Kim Rubin. And so we want to make sure that we start with, we'll have Kim Rubin.
Richard Oxter is actually going to be presenting because I might need to leave, but we're basically going to be talking based on some of what was done during the DC Tax Revision Commission, which I was a member of in Richard's staff.
Sure. And we have a number of other people who testify, or at least signed up to testify, and we're going to call them as well shortly, but we'll start with, how do you pronounce your last name?
It's Oxter, Councilmember Duffy.
Got it. Thank you so much for being here. You can begin your testimony.
Thank you, Councilmember. And thanks to the entire committee for giving us a chance to testify today. My name is Richard Oxter. I'm a senior policy associate at the Urban Institute, and I was a staff member on the DC Tax Revision Commission. And I'm joined by my colleague, Kim Rubin, the sole Price Fellow at the Urban Institute and a member of the commission. Kim and I are testifying on our own behalf, so our testimony should not be applied to our organizations or to any other members of the commission, although we will faithfully express the findings and recommendations of that commission as were reported in its 2014 final report. Kim and I would like to make 2 points today. The first is that the commission made a package of reforms with some of those reforms working in concert. Specifically, while it recommended eliminating a pension exclusion, it simultaneously recommended increasing the standard deduction because the commission felt that was a more efficient way to provide tax relief to district residents. And two, we should analyze the current proposal in the current DC tax system. Because given the changes to the DC tax system, the larger standard deduction, most of the benefit of the current proposal will go to relatively high income households. The DC Tax Revision Commission held 26 meetings, 3 public hearings, and heard from a range of tax policy experts. It eventually made a package of reforms, but we're going to focus on 2. 1, conforming the district standard deduction and personal exemption with the federal amounts, and 2, eliminating the pension exclusion. By conforming with the federal amounts of the standard deduction, DC increased the standard deduction by thousands of dollars. And this provided tax relief. In fact, DC's ORA found that the package of reforms provided hundreds of dollars in tax relief to most district residents. But it also allowed us to recommend simplifying measures like eliminating some tax expenditures because we were able to get rid of these tax expenditures without creating a larger tax burden for those residents who were previously claiming them. That brings us to the current proposal to increase the exclusion for pension income. And we'd recommend analyzing it within the current district tax system. Because since we made those recommendations, Congress has since further increased the standard deduction. So now currently we went from a standard deduction of about $4,000 before the commission to a standard deduction of $13,000 for single filers and $25,000 for married filers. As a result, the proposal that's being put forward, which would create an exclusion of $10,000 or $20,000, depending on the filer's age, DC households would have to make above those levels, above $13,000 and above $25,000 before they could benefit from it. That's why during a preliminary analysis, we found that the exclusion would give 2/3 of its benefit to households earning more than $75,000. If the district wanted to better target this exclusion, it could do something like placing an income cap limit on the exclusion. But in general, we recommend analyzing this proposal, taking a look at the district's broader tax system, and weighing the trade-offs to see if it's worth the fiscal cost. Thank you very much, and we're happy to answer any questions you might have.
And thank you for providing testimony this morning. I want to note that there's some witnesses. I think staff is having some technical difficulties transitioning all of the public witnesses over as participants. And so I'm going to call the names as they appear. I do see Sylvester Bush, who's present, but I know that staff has already indicated there are some challenges. So let me turn next to Sylvester Bush.
Good morning, Chairman McDuffie and committee members. I would like to have a moment of silence for those who are no longer with us, but who were part of this 7-year advocacy effort. Thank you. I am Sylvester Bush, a veteran, a retired federal employee. I represent the Coalition to Restore the DC Pension Exclusion. We are a coalition of retired DC military, teachers, firefighters, police officers, DC civil servants, federal civil servants, and others who have come together to demand passage of a long pending bill that would eliminate taxes on up to $20,000 of pension income. We support the passage of a fully funded bill 240071, the Pension Exclusion, Restoration, and Expansion Act of 2021. In 1957, Congress enacted a law that allowed retired military persons and civil servants to subtract $2,000 from their pension income when they filed DC tax returns because they realized they were selfless, they sacrificed, and they served every day for lower pay. The law stayed in effect during the crack pandemic and the DC Control Board era when DC was at its fiscal nadir. However, it was repealed by the DC Council when DC was at the zenith of its prosperity in 2014 and became law in 2015. The financial impact of the 2014 repeal has been a loss of purchasing power while on limited income. Senior tax relief at the federal and state levels is grounded on a recognition that seniors' income decline at the same time their medical costs, property taxes, and other expenses are rising. Financial distress among the aging is increasing. The benefit of passing Bill 240071 will help offset medical costs, property taxes, food, and other expenses, and dissuade residents from leaving the district. Maryland provides $34,300 pension exclusion for tax year 2021. Notice that when we started this, it was at $27,000 and it's indexed for inflation. We were there loyal, faithful, and consistently contributing to the DC Treasury with our sales tax, income tax, and real estate taxes during the crack epidemic, Control Board era, zenith of prosperity, and a pandemic when tourism, hospitality, and the restaurant sectors were decimated. We are still here, selfless, sacrificing, and contributing to the DC Treasury with our sales tax, income taxes, and real estate tax. The hopes of 40,000 plus retirees, which include 455 military retirements that lived in the Armed Forces retirement home, where the average age is 84, have been raised and dashed for the past 6 years. It is past time to end this dismal cycle and enact a 20,000 tax exclusion. I want to make a correction. When we started, there were 455 veterans at the Soldiers Home. Now there's only 233. Some of them have left the area. I appreciate your opportunity. Thank you for what you guys are doing. I'm available to answer any questions.
And thank you for your testimony, Sylvester Bush. I'm going to call Laura Richards, who I know has expressed interest in this. I don't see her present.
Ms. Richards is in Hawaii, so I don't know if she's going to be able to connect or not.
Got it. Okay.
But she did submit her written testimony.
Okay. I know she certainly mentioned this bill when I saw her 2 Saturdays ago, and so I wanted to make sure I didn't miss her in case she was present. But I'll turn next to Dr. Atto. And good morning to you. You can begin your testimony. If you want to unmute yourself, I don't know, having trouble seeing your face. I know your video is on, but. I'm getting a lot of feedback. I'm not sure if you can hear it as well, but you may want to see if you can adjust that. Because I can't hear anything if you're speaking. So yeah, if you can try to address that, then we'll call you again shortly. But we're gonna move on next to, I'll call John Satoli. I know we have Mr. Satoli's written testimony. We appreciate that. Linda Jones. Right. I still have the feedback, Dr. Eto. So, yeah. I called Linda Jones, don't see Linda Jones present.
We submitted her as also in writing. I think what happened was a lot of people submitted and they're not going to be actually testifying.
No, it's fine, Mr. Bush. I like to call people just for the record. So I do have a list from staff that's provided for me, all the folks who provided their written testimony. I just want to give people the opportunity to know that I've called these witnesses who took the time to previously sign up. Randolph Clark. I see a person with the last name Randolph. I'm not sure if that's somebody different. Okay, Steve Caffin. I don't see. Racine Randolph, I do see. And Dr. Attal, I'm gonna ask you to work with staff to try to figure out a better way to be able to provide your testimony, because we're still hearing feedback whenever you unmute yourself. Racine Randolph, good morning. I'm not sure if you want us to be able to see you via your video, but we cannot see you, and we don't hear you if you're talking. Racine Randolph. And if you're able to use your audio only, that would be purposes of this hearing. Okay. I think we're seeing Randolph is experiencing some technical difficulties because we do not hear or see you if you are attempting to testify.
Chairman McDuffie, can you hear me now?
I can hear you. Yep.
Okay, yes, I do apologize. I am experiencing a technical difficulty with my camera at the moment. To yourself, sir, and district council members, first off, I would like to say thank you for your service to our district and for the opportunity to testify today. I am Lieutenant Colonel Racine Randolph, a resident of Ward 8 and a West Point graduate with 21 years of Army service. Currently, only 1% of the US population volunteers to serve in the nation's military. And as of September 2020, there are only 2,337 military retirees in the District of Columbia out of approximately 693,000 residents. This translates to military retirees being only 0.3% of the district's population. I come before you requesting your support in proposing a friendly amendment to legislation B24-71, Pension Exclusion Restoration and Expansion Act of 2021. My proposal is to break out military retired persons as a separate and distinct retirement category, and to offer this population, 0.3% of the district, a $20K tax exemption on military pensions without any requisite age. This 0.3% of the population answered the nation's call to protect and defend this nation at all costs. I implore the district to distinctly honor their service and sacrifice. Please remember, many states exempt all military retirement pay and certainly exempt property taxes for disabled veterans. Amending this legislation for 0.3% of the district's population would have a positive fiscal impact on the district by attracting more military retirees to choose the District of Columbia as home, just as my family has done here in Ward 8. Thank you for your time and consideration, and I stand by for any comments or questions.
Thank you for your testimony this morning. I see that there's been another Sylvester Bush appear on my participant, appears a participant on the screen. And I'm not sure what that is about, but staff, I'm going to turn to you. If are there witnesses who are able to testify with their audio only?
Yes, sir. We can just name them one by one if you'd like, and I give them permission to speak.
Okay, that sounds good.
Let's start with Patricia Rozier.
okay? I see Patricia Rozier. I see your hand is raised. You can begin your testimony if you're able to allow your audio. I can hear some background noise, Patricia Rozier. If you want to testify. Steph, I'm not sure if this is going to work for Patricia Rozier because I cannot.
Yes, sir. If you like, we can try Mr. Randolph Clark.
Let's give that a shot. If you are able to unmute yourself, Randolph Clark, and you can begin your testimony. So Steph, how about we do this? I'm going to go and do a 7-minute round of questions for myself and Councilmember Gray. And while we are asking questions in this first round of the witnesses who are present, perhaps you can work with the other witnesses to maybe sign out and try signing back in to provide their testimony. I do see Dr.
Yes.
Yes. And if you would like to go ahead and provide your testimony, you have 3 minutes to do so now. So before we do a round, we'll let Dr. Atal provide your 3-minute testimony now. Good morning.
Thank you. Thank you. Good morning, everybody. Good morning, Mr. McDuffie, Chair, and distinguished committee members of the Business and Economic Development. My name is Goziem Ato, and I'm testifying on behalf of the Washington Teachers Union, Retirees Chapter. I have lived in DC for over 50 years, during which time I taught at the District of Columbia Public Schools for over 30 years, as well as at Howard University. As a Ward 1 resident, senior citizen, and registered voter, and member of the Washington Teachers Union, Retirees Chapter, I please urge you to support the reintroduction and passage of the Pension Exclusion and Restoration Expansion Bill, B240071, which will enable retired DC public servants and military personnel to eliminate taxes on up to $20,000 of pension income. Prior to 2018, DC taxpayers 65 years of age and older received a personal exemption when filing taxes. The passage of B240071 by the City Council of the District of Columbia will demonstrate that the council supports senior citizens as valued residents of the city. Our former DC public school colleagues that reside in Maryland revealed that they are exempt by up to $33,000 of public and private pension income from taxation after they turn 65. This modest benefit from this bill, B240071, will assist us financially as the cost of living in our city continues to increase. I will greatly appreciate communication from you on your support of the passage of this bill, B240071, as the passage of this is important to my fellow retired DC public servants, military personnel, and me. Thank you very much for giving me the opportunity to speak to you. And if they say any questions, I will be ready to entertain. Thank you very much, Mr. Chairman.
Thank you for your testimony. We appreciate you taking time to provide it. We're going to do staff 7-minute rounds for myself and Councilmember Gray, and I'm going to start with Kim Rubin and Richard Oxer. You both participated in the Tax Revision Commission process. I understood you to testify that you were staff to that commission.
Yes, sir.
So Richard was on staff and I was one of the commissioners. And I did work on the low income panel, which I chaired, which is a subcommittee.
Okay, great. And so just if you could, just for context, share the commission's general goals and what you all were convened to do on that tax revision commission.
So the commission was given like both its specific goals and a range of goals that kind of boil down to making district's tax system simpler, more equitable, and more competitive. What's challenging is that in tax policy, sometimes those goals can interact with each other or even like, counterbalance each other. And so that's why the commission put forward a package of recommendations, because it knew that some of its recommendations had to counteract or interact with some of the other recommendations. And this goes to eliminating some of the tax expenditures like the one we're discussing today. It was eliminated to make the code simpler. Fewer expenditures makes the code simpler, but we didn't want anyone's taxes to go up. And so correspondingly, we rose the standard deduction so that while some filers might lose that particular expenditure, they would benefit from the broader deduction, which would also be going to other residents and giving them tax relief as well.
So for those who testified in support of this, and there appears to be a lot of support for, in particular, the reestablishing the pension benefit, what would you say to them in terms of the sentiment that they lost out on this benefit? They used to be able to get this deduction. They could no longer take it after, I think it was 2014 or so. What did, if anything, did they gain in the work of the Tax Revision Commission when this was removed?
So their tax bill, if they compared it with the prior year, probably went down because of the bigger standard deduction. But of course, losing something that feels specific to you might be more visible. So whenever you get rid of tax expenditures, people notice when things go away. And so the fact that they suddenly had to include their pension income, even if they might not have had tax liability on it, may have been a signal. We're also not saying that it is inappropriate for the commission to think about introducing or extending a pension benefit. Many states have something like that. Many of the states that have them actually offer a much smaller standard deduction. So on net, it might not be as beneficial for lower income retirees in the district as it is to other places. It's more that at the time that we were doing reform, we were trying to simplify the code in a number of ways. We did a number of other things, including increasing Schedule H also increased and became refundable. So part of it was trying to figure out whether we could simplify some of the things that were quirky about DC's code. The fact that DC didn't have separate schedules for singles versus married folks and everything was the same groups was different than what we found in many other states or in the federal code. So by making it more similar to the federal code, it was a way of making it easier for people to do their taxes, but there were some specific exemptions that were decreased. But as Richard said, when we looked at sort of overall tax bills, they went down for everybody. They probably just went down less for people who had been getting that benefit before.
If I could just quickly add to that, Councilmember McDuffie, to Kim's point, I first want to acknowledge the service of Mr. Bush and Ms. Randolph, and that there absolutely is, worthy. But in tax policy, so something Kim brought up, it's very challenging to compare one district or one state to another because the individual part might be masking larger trends. And again, while the district got rid of this specific exclusion, the work of the council, both after the recommendations of 2014 and in policy changes since then, has greatly reduced taxes for district households and made the district system more progressive. It's not just the standard deduction, it's that they've lowered tax rates for middle income households. It's that they've expanded the earned income tax credit for low income working families. So again, while this part of the code might look smaller when you compare DC to others, in general, the district code is far more progressive than these corresponding states, even if it lacks this one part.
Let's assume that folks who support this bill understand what you just mentioned, what both of you just mentioned, in terms of the standard deduction and other ways that middle income households have benefited from tax policy changes by the council over the years. You still have, I think, some people who, and I don't want to put words in anybody's mouth, but they see a benefit of passing something like what's included in Bill 24-71. I think Mr. Bush, I'm going to call him next, says in his testimony that it will help offset medical costs, property taxes, food, and other expenses and dissuade residents from leaving the district. He points out that Maryland provides $34,300 pension exclusion for tax year 2021. It's my understanding that Maryland doesn't have the same standard deduction, though, as the district. So how would you two respond to the point that is made in Mr. Bush's testimony, and I think by a number of other witnesses who support this? And then, Mr. Bush, I'm going to turn to you at that.
So I would just say that budgets can represent the priorities of a jurisdiction. And so it absolutely can be the case that we could decide that we want to introduce this or reintroduce this because we feel that these residents will need more help. The only points we want to raise are questions about, we're basically giving a benefit to DC and federal workers, but not other public sector workers and not other private sector workers. So if the district feels like retirees need more assistance, that's something to think about, and think about how it fits into the entire package of what taxes are. Mainly, our argument isn't to pass or not pass this bill. It's more to think about how it works with other parts of the tax system and whether it reflects the priorities that the district is trying to reach. And so partly, we're just saying, in part also, to think about who is actually getting the benefit, and if it looks like it is more expensive than you think it needs, like if you feel like it's more costly given other goals, there are also other ways that we talk about in our testimony where you can actually target it more. Other states have put in things like income limits. So if you thought that you wanted to target it for lower middle income retirees, there are ways of doing that too. And so part of it is just to sort of look at the broader picture and how it fits into the tax system in the district.
And I'll sum this up very quickly, but Councilmember McDuffie and Councilmember Gray, this just speaks to why your job is challenging, because you will hear from lots of deserving residents who do deserve tax relief. And it's your job. It becomes difficult to pick winners, and I don't want to say losers, but to pick people who would benefit this through specific tax policies. And that's why, in general, people like Kim and I recommend broad tax relief that applies to all residents, such as the standard deduction and such as Schedule H. Thank you.
Appreciate that. Mr. Bush?
Yes, thank you very much. There's a few points I want to make is that most people come to the council asking for money. We didn't. Congress in 1957 recognized that retirees, military teachers, all those that at that time DC was under OPM, required an annuity exclusion because they made less. They recognized that in 1957. Okay, and like I said in my testimony, all throughout when DC was struggling at height, we took it away. Okay, and so they keep talking about broad base, but see, DC is unique because 50% or more don't itemize. They don't use a standard deduction, so that doesn't impact that. Okay, and before the bill, DC had two tax classes. I think 400,000 and above 400,000. When they took the $3,000, they created this new tax bracket from 40,001 to 60,000, and then they lowered the rate to like 6%. And that was for the new people coming in. And that's what the tax did also. So when you have a benefit and you take it and give it to everybody, you can't say it's a benefit. we lost something. Okay, like I said, the federal government, Congress recognized that we needed this to offset that. Also, we're losing, again, like I stated, if you look, we contribute to the Treasury through real estate taxes, income taxes, and sales taxes. Now, and we were taken for granted through those years, but the pandemic, your main sectors of income, tourism, hospitality, and restaurant, was decimated. But yet we were still contributing to sales taxes, income taxes, real estate taxes. Now, there are some people who have left the district, they just can't deal with it. And so the thing is, you have to balance that, like the people are saying, they're not against it, they're talking broad-based here. But I'm saying is that the folk that have been loyal, steadfast, still here, no matter what happens, who's in office, whether there's crack, whether it's good during the pandemic, they're still here. You can't continue to overlook those people because eventually Maryland looks very enticing, okay? And that's on all pensions. We're just talking about the 40,000 plus here. So, and some have gone to Florida, some have left. And in some of the testimonies were submitted, you see some of them are left because it's about the dollars.
Yeah, no, I read that. I read that in some of the testimony. I appreciate that. Let me turn to Councilmember Gray for a round. Here we go.
Thank you, Mr. Chairman. I appreciate that very much. Mr. Bush, I'm not going to ask you to speak for Ms. Richards because she does a very good job speaking for herself. She's not here today, and I don't have any doubt we'll get written testimony from her if we haven't gotten it already. But I want to give you an opportunity to speak to issues around what you think the hardship will be created for people who are beneficiaries. You all have come before me heretofore. She's come before me heretofore, and you all have made a very compelling case. So I want to ask you again if you can make your compelling case on behalf of Ms. Richards as well around why this bill will benefit people. Who will be the beneficiaries, and what will they suffer as a result of not being able to get this opportunity available to them?
Like I stated that, okay, you never want to make a decision between food and medicine and paying your rent. You know, those shouldn't be options that you should have. I mean, like I said, when we started out, there were 455 veterans living in the armed soldiers home. Okay, this morning there's 233. They left. You know, it's hard to. DC is a high income area. Okay, and then if you're on limited income, not necessarily fixed, but because we do get the cost of living, but if you're on a limited income and everything is going up, and then especially in the economic situations we're dealing with inflation right now. So you have to decide whether should I get meds, should I get food, should I, pay rent, okay? And then if you got medical bills, some have medical insurance, but you have to consider with that, you have to take that into consideration also. And then if you're trying to save, so it's like I said, it's the food, it's the property taxes, it's the rent. Even though you have property, the senior citizen and the senior deduction, which is 50%, but that's still, if your income is limited and your expenses are exceeding that, then you're going to have a problem meeting those expenses. Okay, and it's all about dignity and respect. People don't really want to ask. They want to be able to take care of themselves, but when they're forced to, they're going to look to Maryland, they're going to look to Florida, they're going to look to those states that are more friendly towards them when they retire. One other thing is that I did, when we initially started, because I've done taxes for 32 years, I volunteer with the IRS called VITA, and that's how I found out that this was missing. So we took 10 random people from different wards across the city. And we plugged in the numbers using TaxWise, everything, and everybody lost money. Everybody lost money that we ran as taxes on. So going through this, and we presented that in our testimony back in when Jack Evans was here. And Mr. Evans at the time said that this was a mistake and he wanted to rectify it, but he never did. So, I mean, sometimes when you do that tax modernization, you, like you said, you did that broad base, but sometimes you make a mistake and you have to go back and correct that. And I think this was a mistake that was made that needs to be corrected. Did I answer your questions, Councilman Gray?
Yes, you did. Thank you very much. The only other question I have is, you mentioned Maryland. What will be the, let's say that somebody chooses, and you don't live in Maryland, I know that, you live in Ward 7, so I appreciate that, as does Ms. Richards. But I just want to make sure I understand that if you were choosing to Maryland, move to Maryland, what would be the benefits that would accrue to you as a result of moving to Maryland or some other jurisdiction other than the District of Columbia?
I'm glad you asked that because we ran a lot of scenarios. I mean, I don't want to seem like I'm the smartest guy, but we reached out to PhDs, PAs, and everything. And we ran a scenario of a married couple living in DC at that time when we ran the scenario, and one in Maryland. And the one in DC would pay like $3,300, based on a scenario we used with the income and everything. They would have paid $3,300 or something. The one lives in Maryland would have paid something like $1,500 in taxes.
Mm-hmm.
So you almost had like a $2,000 difference just from leaving. Like I said, and we did apples to apples. You know, we said, okay, single person, married person. Okay, then we ran everything down the same way because, like I said, on these TaxWise software, you just plug it in and then you change it, and it will give you that at the bottom what your tax liability was. And so for Maryland, it was like a $2,000 difference or savings on your tax liability as opposed to if you live in DC. And if you go to there's I think I believe there was like 41 states have broad base, and there were 38 that have some type of pension. DC had that until 2014. Okay, what they offer. So there's like 36, 37 states that give some pension, and like the Lieutenant Colonel said, is that some even do the military. Now, when you go to Maryland, see, they have more than just a pension. They have, if you're a first responder, they have another tax thing for you. You know, they have other ones that they give you. So that's just the base of is the pension. But like if you're in other categories, they give you more. So we're out of line if we're saying that, you know, we want it to be a state. We're mutually exclusive to being a state right now because majority of the states, they offer that. And so, and the other states, Maryland is indexed for inflation. When we started out with this in 2015, their deduction was $27,000. It's $34,300 now. So they're every year they're increasing that, and that's for their whole population. It's not just ours is restricted to just those that get a 1099 from OPM or DC fire teachers.
Okay, thank you, Mr. Bush. I appreciate the expansive answer that you gave. And that adds to the record that, you know, we've tried to amass on your behalf and Ms. Richards' behalf as well. So thank you, Mr. Chairman. I appreciate the opportunity. I realize I ran a little over my time, but I did want to give Mr. Bush an opportunity to further elaborate on the answer that he gave for his testimony. So thank you, Mr. Chairman.
Thank you, Councilmember Gray. I want to turn to Kim Rubin. I see your hand is raised.
Yeah, I just wanted to, part of what happened and part of why this seems more out of whack is in part because DC is now more conforming with the federal government. And so when the federal government actually eliminated its personal exemptions, DC did as well. So I just wanted to agree that what we're talking to is generally true for people who are taking the standard deduction. But if people are itemizing and they don't take that standard deduction, you won't necessarily get that benefit. It's just that more people can take the standard deduction and have it be simplified. So I just sort of wanted to acknowledge that what we were thinking when we did this as part of the DC Tax Commission, things did change after the federal government passed TCJA, which basically got rid of the personal exemption, which also meant that the senior exemptions also went away or were limited. So the fact that DC was piggybacking off of the federal government made some of these differences greater.
Sure, and just for the benefit of people who might be home watching, we talked a lot about middle income individuals and families, but I think it might be important to toss a question out to you about our lower income households. Where, if at all, do they fit into this entire discussion about, pensions and exclusions and things like that, generally speaking?
Yeah, so Councilmember McDuffie, low-income households almost universally take the standard deduction because they don't have enough things like mortgage interest or state and local taxes to itemize their taxes. And that means that in the District of Columbia, they are taking either the $13,000 if they're single or $25,000 if they are married. That means that these families must earn above those amounts before they can benefit from this exclusion. Again, that's a very good thing. That's a very progressive change that the district made. It means a lot of low-income families don't pay income tax in the district, but it makes deductions and exclusions like these more challenging because, as we noted in our model run, in general, overall, again, like individual taxes may vary, overall, this would benefit households earning more than $75,000 because they have the income greater than that. And so to assist a low-income household, you would need to pass things like refundable tax credits, which the district has, like the earned income tax credit, or it could possibly create a separate refundable tax credit for anyone on retirement income. But in general, because those have relatively high standard deductions, it means that most seniors don't have much of any taxable income, which means they can't benefit from exclusions or deductions.
And we find that a very small percentage benefit from this. I think it was something like 6% of households with under $50,000 who have retirement income would benefit from it. But that does not mean it isn't worth considering. It's just knowing that it is going to be something that will largely be a benefit for middle and slightly higher income families because they are the ones who are itemizing and they are the ones who may have lost some of the benefit before.
I appreciate that. I want to give Sylvester Bush, I know how hard you've worked on this and I appreciate your dedication to this issue and that of Laura Richardson as well and others. I know Barbara Morgan has contacted the office about this as well. Mr. Bush, I want to give you another opportunity to add anything else on before we turn to our government witness.
Yes, I just wanted to say is that just to keep what our scope is, what her response was, is not within the scope of the 40,000. Now, like we were talking with the AARP folk to help us with this, and we're not opposed to, like, if the district wants to do an exclusion for everybody, but we were focusing on restoring what was taken from those pension annuity folk. So I want to be clear about that. So what she's talking about, if the district wants to do for everybody like Maryland does, we're not opposed to that. But what we're saying is that we want to have our exclusion. But what she mentioned before is not really not in the scope of our folk. Am I clear on that? Let me
make sure I understand. When you said the district could do like Maryland does for everybody.
Everybody that gets a pension retired. Right now, it's not like that. Okay, right. So if they want to do that, that's fine. But that wasn't our initial thing was on exclusion. But however, if they wanted to do that, then that's fine. But we're saying what we wanted was what we lost back. Okay.
I understand. Thank you for that. And Dr. Attal, thank you for your testimony. I know you talked about the teachers and their benefit, and I appreciate all that they do and your testimony on behalf of them. Richard, Osher, Kim Rubin, anything else that you all would like to add to the record? We know we have your written testimony. But if there's anything else you'd like to add before we turn to our government witness, I'll give you that opportunity now.
I'll just add that the tax policy, it's very hard to understand the inner workings of the entire system. And the challenge for your office and Councilman Gray's office is trying to align the goals of this policy with the outcomes of the proposals. So I think what Kim and I are just trying to stress is that while this may be a very worthwhile proposal as is, it would assist those who have given public service to look closely at those who would benefit based on their household income. And if that's not exactly what you're trying to do, you would then just have to make a different proposal. As Mr. Bush has alluded to, you could possibly include all pension income. You could possibly create a tax credit instead of an exclusion. And that while it might, maybe this is a good first step discussing what had been, you might want to get more creative if you think through who you want to actually benefit from this new tax proposal.
That's very, very helpful testimony. And I appreciate each of the witnesses providing it here this afternoon. And I'm sure there'll be some follow-up with the committee and perhaps also Councilmember Gray about the way that this is drafted. I think we'll hear some testimony from the CFO about some modifications that, if this does pass, they would like to see. I saw a red line version that they have provided to the committee as well. So thank you for your testimony again today. We look forward to following up with you. We're going to turn now to Alyssa Borges with the Office of the Chief Financial Officer. Good afternoon to you. Thank you for being here. You can begin your testimony.
Good afternoon, Chairman McDuffie, Councilmember Gray, and members of the Committee on the Business and Economic Development. I'm Alyssa Borges, Assistant General Counsel for the Office of Tax and Revenue for the District of Columbia. Thank you for the opportunity to provide comments on behalf of OTR on Bill 240071, the Pension Exclusion and Restoration Act of 2021. The legislation seeks to amend two sections of Chapter 18 of Title 47 of the DC Official Code by restoring and expanding district income tax benefits for 1, retired federal, military, and district government employees, and taxpayers who itemize deductions and pay long-term care insurance premiums. The First Amendment amends DC Code Section 47-1803.02 A to N and restores and expands an income tax exclusion for certain retirement income received by federal or district government retirees. Just by way of background, under district law, in general, the starting point for determining a district's residents' liability for district income taxes is the calculation of the taxpayer's federal gross income. Specifically, DC Code Section 47-1803.02 provides that district gross income has the same meaning as federal gross income under Section 61B of the Internal Revenue Code. Under Section 61B, all income from whatever source derived is included in federal gross income, and therefore is included in district income absent a specific statutory exclusion. DC Official Code Section 47-1803.02A2 lists over 40 such exclusions, meaning these are the ones where the DC Council has said, we're going to, as a matter of statute, specifically include these specific items that are taxable under federal law. We're going to say they're not taxed under district code. Historically, and what we've been talking, the panel's been talking about here today, is Section 47-1803A2A2 excluded pension, military retirement pay, and annuity income up to $3,000 received from a DC or federal, or received from the District of Columbia or the federal government by persons who are 62 years of age or older. So $3,000, it had to be paid by the District of Columbia or the federal government to a person who was 62 or older. However, the fiscal year 2015 Budget Support Act of 2014, which was effective in February 26, 2015, effectively repealed this exclusion for all tax years beginning on or after January 1st, 2015. As you've heard from the other panelists, this change was based on recommendations set forth in the final report of the District of Columbia Tax Revision Commission. This bill that we're here discussing today seeks to restore this exclusion and also to increase it from $3,000 to $10,000 for retirees who are age 62 and 63, and then up to $20,000 for ages 64 and older. So it would restore it, but it would increase the limits based on, up to 10,000 and then up to 20,000 once you hit age 64. OTR can administer this exclusion as contemplated in the bill. However, based on OTR's past experience in administering this exclusion prior to 2015, OTR recommends certain technical changes that will provide clarity to both taxpayers and OTR. For example, in the past, there was confusion in erroneously interpreting this exclusion as providing a $3,000 exclusion for each spouse for a total exclusion of $6,000, even when only one spouse was receiving a government pension. To remedy this, the OTR suggests changes that will clarify that the exclusion will be per retiree, not per spouse. OTR also suggests adding express language regarding the specific year to which the statutory change restoring this exclusion will apply. To assist in your review of the bill, a copy of OTR's suggested changes are attached. The bill also seeks to amend a different section, which I don't think there has been testimony today yet, which would be to restore an exclusion, a deduction for premiums paid to for long-term care insurance. This change was also a recommendation recommended by the Tax Revision Commission. Again, OTR it can administer this, but we do recommend technical changes to the bill just for clarity, which are attached as well. And with that, thank you for the opportunity to testify, and I'm happy to answer any questions you may have.
And thank you for your testimony this morning. I appreciate it. I do have some questions, and so staff will do a 7-minute myself and Councilmember Gray. Let's see where I want to start. Do you know, have you looked at in your review of this measure, how many people will be eligible to receive these deductions if this bill were passed?
The Office of Tax and Revenue has not. That would be something that probably would be considered by the Office of Revenue Analysis when they do their fiscal impact statement, which they usually provide an ordinary course at the time of markup.
Okay, that'd be helpful, and I appreciate their work on those fiscal impact statements, of which we've requested many recently. So you all have not done even a preliminary, or the OR, to your knowledge, hasn't done a preliminary FIS to give us a sense of how much something like this could cost?
I'm not aware that where they would stand on that, and I know that they monitor bills and work with the committee to provide the FIS in a timely manner.
I know that they're in communication with the committee staff. I just wanted to see if anything had made its way to your section of the office for this hearing. Do you, I don't know if you have the sense of how many residents currently utilize the standard deduction?
I don't here for today, but we can provide that information. But I can say the vast majority of district residents do take the standard deduction and don't itemize, but we can provide the committee with more detailed information.
Okay. And you mentioned this in your testimony, but I'd like to draw this out and just make sure it's clear. The bill proposed would exclude a portion of the pension income of federal and or district government retirees, and previously that amount was $3,000.
If the amount was previously $3,000, yes.
And this bill proposes to make the amount $10,000 for retirees ages 62 and 63, and $20,000 for retirees ages 64 years old or older.
Correct.
Okay. You mentioned something in your testimony about in the past, the experience with the office with that people were confused about whether the exclusion applied to one person or the person and their spouse combined for $6,000. Any sense on why that confusion existed? Was it just the drafting of the measure, or and I appreciate the modifications that you are proposing in your red line, but I just want to get a sense of what we should be thinking about avoiding if this is something that the council would like to move forward with.
Okay, so if you read the current statute that had the 3,000 and it was appropriate, and I don't fault that. Like when people thought, all right, we want to restore that, let's basically copy that provision and update it. But in looking at that, I don't necessarily agree with this position, but some people interpreted that it doesn't say that the retirement income has to be paid to the retiree. It would basically say retirement income paid by the District of Columbia or federal government. So some people took that the provision that an individual, if they happen to claim retirement income on their tax return, got that exclusion. So for example, a husband and wife, maybe there was one government employee and one private sector retiree, would say, aha, I'm the private sector spouse, but I am claiming retirement income on my tax return, so I'm entitled to deduct. We're each entitled to an exclusion, so that takes us to 6,000. OTR did not support that, position, but there was confusion in that, and so one of the technical changes is to make clear that it's per retiree. So if you had a married couple who each had their own government pension, they could it could be 6,000, or in this case, each 10,000, up to 20,000, or even 40,000 if they were each retirees. But it's based on the government employee, and the spouse, the non-government spouse, doesn't get to automatically claim an exclusion of their own to double it.
Okay, and then if you could just, that was helpful, and I love for you to mention, if you could just expound upon the concerns and your suggestion about language regarding the specific year to which the statutory change.
Right. So,
apply.
Yeah, and this probably goes for, frankly, almost any tax change that this committee would consider ever, is that since we're dealing with an enacted code under Title 47, it's helpful for clarity for, frankly, for everybody, OTR employees and the general public and practitioners, to have a firm date when things apply. And just sort of to that would, so for as a placeholder, we put in December, that would apply to tax years beginning after December 31, 2022. And the language in that was basically said it will apply to the tax year after the effective date of this act, or language to that effect. But that is difficult for down, in a year or two, when somebody opens up Title 47, either a taxpayer or tax prep, they don't know what that is, and they have to look at it. So it's better to have a firm date. Now, I know it's sometimes it's not clear exactly when legislation is going to pass and be funded. So but OTR would prefer to see a firm date in there. And then if the actual year needs to get amended in, for example, a subsequent BSA or something would be funded, and then that can be changed. But it's just, we find it's much clearer for everybody if it's if tax line bills would be, this will take place for tax years starting after December 31st, whatever tax year.
So are you suggesting that there's something that is unclear in the tax code for people? I'm just joking. I should even. Let me, my time has expired. Before I turn it to Councilmember Gray, let me just ask though, you all made a couple suggestions, two of which we just discussed. Are there any other suggestions that you did not include in your oral or written testimony that you'd like to provide on the record today? Or is it all included in the red line that you provided to the committee?
It's all included in the red line. I know there have been testimony by other panelists, on different changes to the legislation that would be more like on a policy standpoint. We don't take a position on that, but to the extent that there are versions and other ones, we're happy to, to review, and if there need to be like technical tweaks to proposed amendments based on a particular goal, we're happy to look at that.
Okay, I appreciate that. And then if there aren't any changes, the committee wants to move forward, we'll make sure that we work with OCFO on those. I'm going to turn now to Councilmember Vincent Gray.
Thank you very much, Mr. Chairman. Ms. Borges, I just want to ask you a question. Have you been approached by, you heard Mr. Bush's testimony, and you probably have heard from Laura Richards as well. She wasn't here today, but I know she's very sophisticated, as is Mr. Bush, on these issues. So have you heard from one or both of them with respect to their views on these issues?
I have not, but others in our agency might have. But I will tell you that when this change happened right before I joined the Office of Tax and Revenue, and I can report that we do hear frequently from retirees who used to get this exclusion, and they're not happy about it, for the reason similar. So I'm not surprised on that. But in terms of whether it would be that we would hear from the advocates on this, like Mr. Bush, whether it's a good policy or decision or not for the district to make a decision to provide a special tax benefit or to restore a special tax benefit to government employees of the federal government or DC, that is something that we would listen, but that's ultimately a decision for the policymakers and
Yeah.
So.
No, we understand it's ultimately the policymaker's decision about this issue. I clearly understand that, but I just want to understand again. You heard the case of Mr. Bush, and you probably will find when you look at the record that Laura Richards has made a compelling case also. Have you heard? Are you aware whether your office has heard of compelling cases of others in the District of Columbia, Ms. Borges?
That would be hard, but in terms of compelling cases, mostly, I don't know that we necessarily hear that, like, here's a reason why we should have this deduction. It's more just a matter of, I used to be able to deduct on my form, where do I put that in now? And then you don't. There's not that exclusion anymore, and sort of educating people on that. Not so much in them making in the case that they should be entitled to one.
Okay. All right. Well, thank you very much for your testimony today. It's very enlightening, and the other witnesses as well. All were very enlightening as well. We want to make sure that our citizens, our people who live in the District of Columbia, are treated fairly, especially in comparison to other jurisdictions. Do you have any views on other jurisdictions and their engagement with this issue, an issue like this?
In terms of just objectively, like there was discussion about the state of Maryland. It's correct. They do provide for an exclusion for retirement income. But as you also heard from the other panelists, that their standard deduction which is what low income and most middle class taxpayers now, is substantially lower than the districts. Matter of like, yeah, we'll give you pension income, but we're going to give you a small standard deduction. The district's like, we're going to give you a large standard deduction. So they're not always, it's not always apples to apples as you heard there. So it's a bigger picture in that. Also, and just to say that there have been changes to the district standard deduction substantially since this exclusion was effectively repealed. That for now, not only the district increased its standard deduction to conform to the federal level, which included a larger standard deduction plus an additional standard deduction for taxpayers who are age 65 and older. And then due to federal tax reform, the feds increased the standard deduction. They basically doubled it. And because at that point, the district was coupled with those amounts, we went along. So when this legislation was passed, repealing the exclusion, at that point, probably the district's standard deduction for a single individual in the first year in 2014, it was under $6,000. Person now who is age 65 and older in the district, it's over 14,000. That the relief that those things, they don't exactly equalize out, but in terms of how the state of Maryland would do it, but it's approaching closer.
Okay. Well, thank you very much for your testimony. I appreciate it very much. And it's helpful in terms of understanding some of the witnesses' views today. And again, Laura Richards is not here. Mr. Bush was here and expressed his views, which are probably very similar to those of Laura Richards, which we will of course look further at their testimony and their statements as well. So I'm done, Mr. Chairman. I think they've been the witnesses have been very clear about these issues, and I'm sure the committee will take it into consideration as it makes its decision on what's next.
We certainly will, Councilman McGrath. I appreciate your participation in today's hearing. Alyssa Borges, thank you so much for your testimony. I want to thank all the witnesses who provided testimony orally during this Zoom, and those who provided written testimony were unable to make it. I know in this last measure, Bill 24-71, people like Sylvester Bush, Laura Richards, Barbara Morgan, and others have really been actively engaged in the conversation around this and engaging the committee with respect to this hearing. And so we do appreciate their participation, especially. I want to thank all the witnesses for all the measures that came before the committee today, all four of them. For those who would still like to submit remarks to the public record for these measures that came before the committee, you can do so within the time frame before the record closes. And the record closes for these measures at noon on Wednesday, March 16th. This marks the end of today's public hearing. The committee will convene again at 9:00 a.m. on Monday, March 21st to hear from members of the public on the mayor's proposed fiscal year 2023 budget. The time is now 12:43 p.m. and this hearing is adjourned. Thank you, everyone. Thank you to staff as well.
Thank you.